Good morning, everybody. Happy Monday and Columbus Day, I think, today. Welcome to the Courtroom Files Live. We will start our week with Mindy Glazer in Miami-Dade.
¿Escuchó lo que yo dije al principio?
Lo escuché.
You didn't hear it?
¿Que sí o que no?
Sí.
I
Okay.
did.
All right, thank you. You understand you can only go back to your father's home one time only with a police officer to retrieve your personal belongings. And if you go without the police or stay there, you will be arrested.
Y también, señor, tiene entendido que solo se le permite a usted volver una única vez a la casa de su padre, a la casa donde vivía, para sacar sus objetos personales de la vivienda y debe ir acompañado por la policía. Si se presenta ahí en la casa sin venir acompañado por la policía, va a terminar en la cárcel de nuevo.
A ver, voy si me lo que no mandé.
I'll go if they'll let me.
All right, he also has an open felony case, it looks like. So I'm going to set a bond. It'll be $1,000. Good luck to you, sir.
También tiene una causa abierta en otro caso abierto, así que en este caso la fianza va a ser de $1,000.
Ok.
Have a nice day.
Buen día.
Ya solo.
Mira, aquí está en español. Disculpa. Este es.
Next is Henrik Anselme.
Yes, ma'am.
Good morning, sir. You were arrested for battery. I will appoint the public defender's office for you. Let me review for probable cause.
Public defender accepts appointment. Is this an address? Do you live by yourself? Or is it with
My
do you
mother.
have another address where you can stay?
Yes, my mother's.
Is the victim your son or your father?
My father, ma'am.
Oh, okay, got it. It's hard to keep track sometimes. Do you have another place to live that's not with your father?
Yes, ma'am. My mother's house.
Fine. So there's probable cause for the charge. You're ordered to stay away from the alleged victim, Benito and Selme.
Yeah.
So do you understand the stay away order I read at the beginning of court? You can't have any contact with them. Stay at least 500 feet away. You can't use or possess any firearms. You understand that?
Yes, ma'am.
You can only return to the victim's residence one time only with a police officer to retrieve your personal belongings.
Yes, ma'am.
Okay, thank
Thank
you.
Okay.
Is he eligible for pretrial or no?
Thank you.
His carjacking case was old. Armed carjacking he did 10 years.
Yeah.
It was, yeah, Your Honor, it was a 10-year sentence and it comes out in,
And what?
I think,
Is that case still open, corrections?
I don't have anything on the card.
I think it was closed already
Okay.
on 2017.
He got 10 years on 2017.
Yes.
We're in 2025.
Yeah.
What happened is, can you run it? Do you know how to corrections? You show any holds for F15-4410 or no?
No, I don't have anything on the card. 15 or
Oh, because they're real old. I guess they sentenced him and he got CTS and all that. That's fine. Sir, you have any money to post the bond?
You said money to post the bond, ma'am?
Yeah.
No,
Huh?
no, ma'am.
Are you working?
No, ma'am. I just had got my ID yesterday because everything was getting done when I got in trouble. I was on my way to get my license next.
Oh,
I think he got out of prison recently.
Mr. Anselme has an address. You could
yeah. I'll give him pre-trial. It's fine. He's paid his debt to society.
Thank you, Judge.
Thank you.
Is there an alternate, Your Honor?
A pre-trial alternate, $1,000.
So you'll have bond.
Okay.
So pre-trial alternate, $1,000. You're gonna have to go to court on November 14th for your arraignment. Have a good day. Victor Ortero is next. Good morning, sir. Do you speak English? Sir, do you speak English? I can't hear you.
Yes, ma'am.
Good morning, sir. You were arrested for a charge of battery. I will appoint the public defender's office for you. So you live in Brandon, Florida. Are you visiting down here?
Yes, ma'am. I was actually visiting a detox center.
All right. Are you staying there or just visiting?
I was actually staying at the detox center. He does live outside of Miami, Judge. And I do have.
Okay, so he was fighting with the victim in the room at the detox center. There's probable cause for battery. I'm entering a stay away order from Frankie Jones, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from her home, at school, and place of employment at all times, and stay.
No objections for no.
You cannot use or possess any firearms, guns, weapons. Do you two live together in?
No, ma'am. No, ma'am.
All right. State's agreeing to an ROR, so that's fine. I'll release you on your own recognizance. Just make sure is she at the same detox facility as you?
Yes, but I have another one lined up already.
All right. So you can only return there one time only with a police officer to retrieve your personal belongings. If you go without the police or if you stay there, you will be arrested. Okay.
7826. How are you?
8726.
Have a nice day.
I'll have a contact information for you. Yeah. That's also our
Yeah. So stay away from the victim. That's it.
What? This address here. Do you have another address where you could stay?
45. 4583.
All right. Next case. we have
West 100.
Alex Mendez. Good morning, sir. You were arrested for battery. Public defender's office is appointed for you. Let me review the probable.
What's the house or apartment?
Una casa.
And the zip code?
Zip code 3318, I think 4 or 5.
84?
Yeah.
85?
5.
All right, he's 70. Sir, do you own your home?
No, it's my mother's name, ma'am.
All right. There's
I-
probable
I
cause
am.
for the charge.
He does have another address where he could stay.
Is he eligible for program or ROR?
Yes, Your Honor.
Okay, sir, you're ordered to stay away from the alleged victim, Alexandra Mendez. No contact with her directly, indirectly, through third parties. You must stay at least 500 feet away from her home and school and place of employment all times. You cannot use or possess any firearms. You understand?
I don't have nothing, ma'am.
Okay, and also, did you hear what I read in the beginning of court? So you can only return to the victim's residence one time only within 48 hours of your release from jail with a police officer. If you go without the police or stay there, you will be arrested. Do you understand the state
But-
order?
Excuse me, I've been through this already.
Really? When?
Yes.
When was that?
Like around a year ago, I've been having problems with my wife and my daughter.
So stay away from them. I guess the cooling off period is warranted. All right, it's 2 counts. You only gave me one stay away order for 2 counts. Who's the other? That's one is his daughter. I guess the other stay away order is the wife, but you didn't give me a stay away order, state.
Yes, Your Honor. Ria Velasquez Mendez and Mendez Alexandria.
Who was the first wife's name?
Alexandria Mendez.
Also stay away from your wife, Alexandria Mendez. No contact with her. So stay away from your wife and daughter. You understand?
Yes.
Thank you.
You can hear last.
You want me to get
All right, good morning once again, everybody. Happy Monday. Welcome to the Courtroom Files Live. Actually, decent amount of action out there this morning, more than I thought there might be. I thought we would see more courts taking the day off today, but there's a lot going on. Let's change it up. Let's go to Wade Mercer, first appearances.
Mr. Godfrey, good morning. Mr. Godfrey, you're here because you've been accused of one count of fleeing or attempting to elude. You've been accused of the 3rd-degree felony version of this, not the 2nd-degree felony version. Mr. Godfrey, there is probable cause for the charge. Mr. Godfrey, I think you're entitled to a bond. Let me see if the attorneys have any additional information before I set your bond or your release options. Mr. McDaniel, anything?
I would just ask for maybe a cash bond.
And I think I told you, your grandmother's in the courtroom. If I didn't say that, I meant to. Your grandmother is here. Mr. Mitchell.
Yes, sir.
Nothing at this time, Your Honor. Wait, did he say cash bond?
He asked for a cash bond.
No objection.
Mr. Godfrey, what I'm gonna do then is I'm gonna set you a cash bond. You have no history, at least that's what I've got, is no criminal history. Is that right, Mr. Godfrey?
Yes, sir.
How old are you?
19.
All right, with no history on that charge, I'm gonna set you a cash bond of $250. Ma'am, what that means is he's asking for a cash-only bond, so he can't go through a bondsman. His bond is $250. When that bond is released, when that bond is posted, he'll be released. There's advantages to a cash bond. The biggest advantages are if the case is dismissed, it's returned to whoever posted it. If the case is not dismissed, it goes towards court costs and fines. So it doesn't go to a bondsman. But it's $250 cash bond. When it's posted, he'll be released. Do you have any questions? Mr. Godfrey, do you have any questions?
No, sir.
All right, sir. Wish you the best.
Thank you.
The next case that has friends or family here is Mr. Jackson, Tommy Jackson. Mr. Jackson, your father's in the courtroom. Mr. Jackson, you're here because you've been accused of one count of fleeing and attempting to elude law enforcement officers. Actually, a judge first appeared to you this weekend on that charge and already set a bond. The second charge, a violation of probation, looks like you're on probation on 3 different cases. The judge held you till today, till we could see you on the VOP. So, Mr. Jackson, let me see if I'm probably going to do like I normally would do in this kind of case, but I want to see if the attorneys have any additional information before I make that decision. Mr. McDaniel, anything else?
Nothing, Your Honor.
Mr. Mitchell. So, Mr. Jackson, I'm not going to give you a bond. You're on probation, 3 different case numbers, and you're accused of fleeing and eluding. What I'm going to do is I want to put a time limit on them. I don't want you sitting there for weeks and weeks for them to make a call. So the time limit we use now is 7 days. So that 7 days starts today because today's the first day probation and could be notified of the arrest. So I'm asking Mr. Mitchell to notify the probation office of the arrest. They have 7 days to seek a warrant from the felony judge, Judge Garcia. Judge Garcia will review the case and she'll decide, number 1, whether or not to issue a warrant, and number 2, whether or not to put a bond on that warrant. The vast majority of the time, new charges result in no bond VOPs. But they've got 7 days to do that, and we'll see if they get a warrant within 7 days. If they don't get a warrant, that hold is then released next Monday, and you're free to post the bond. If they do get a warrant, we'll see if the warrant has a bond on it or not, but there's a good chance it won't have a bond. Just be aware of that possibility. I'm gonna see if your dad has any questions. Sir, any questions? Mr. Jackson, do you have any questions?
Is that 7 business days or just 7 days in general?
It's 7 days starting today. It's not 7 business days. That's a good question. It's
Yes,
7
sir.
days starting today. I will see you next Monday, and
Yes,
we'll see
sir.
if they got a warrant or not. Okay?
10-4.
Have a good day. Thank you for coming, Mr. Jackson. That's it for friends or family here in the courtroom. So we'll go back to the top of the list. Y'all feel free to leave if you want to or need to. Now we're going to go through the list. You're also welcome to stay if you want to. The next case is Kenneth Jimenez. Mr. Jimenez, good morning. You're here because you've been accused of one count of battery. Mr. Jimenez, there is probable cause in the charge. The problem is, Mr. Jimenez, it looks like you're already on bond out of Washington County. So let me see if the attorneys have any additional information, and then I'll set your bond and give you some more instructions in just a second. Mr. McDaniel, anything else on behalf of Mr. Jimenez?
Nothing, Your Honor. I mean, it's not a major
Mr.
crime or anything, but I don't know if Washington County, I kind of doubt Washington County revoked it on that, but they may. I don't want to say they won't.
Mr. Mitchell?
Nothing at this time, Your Honor.
Mr. Jimenez, I'm going to set your bond today at $5,000 cash or surety. Don't try to post it because I'm going to hold you with no bond for 7 days. I'm going to ask Mr. Mitchell to notify the authorities in Washington County. It looks like he's got a pending charge 25-262CF. 25-262CF is the one he's on bond on. He's been on bond since the end of July. So, Mr. Jimenez, I'll see you next Monday. If they have a warrant out of Washington County, we'll see if they give you a bond or not. They may revoke that bond that you're on. They may not. I have no idea. But if they haven't, by next Monday, I'll release that hold and you'll be free to post the bond I set here. I believe I said $5,000 because he's already on bond. You do have a condition of no contact with the alleged victim in the battery charge here. That starts immediately. So, Mr. Jimenez, you can have no contact with the person that's the alleged victim in this case. But you will get to use the phone in a few minutes to contact anyone else you wish to tell them what's going on with your bond status before I see you next Monday. Any questions, sir?
No, sir. October 27th.
Have a good day, sir.
9 o'clock. October 27th, 9 o'clock.
Thank you, Mr. McDaniel. Corporal or Sergeant, please give him a notice for that October 27th court date. We've already seen Mr. Godfrey. Mr. Griffey, Stephen Griffey is next.
Judge right quick, Miss Godfrey did have a question she wanted to
I
ask.
think Ms. Godfrey has a question. Yes, ma'am. Go ahead. At the jail. Cash bonds are posted at the jail. Yes, ma'am.
Yeah.
250. Yes, ma'am. Yes, ma'am. Mr. Griffey, good morning. You're here because you've been accused of 1 count of possession of methamphetamine and 1 count of driving while licensed suspended or revoked knowingly. I've read the complaint. There is probable cause for those charges. Mr. Griffey, I think you're entitled to a bond. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Griffey, I'm gonna set you the normal bond I set for this charge, sir, which is $5,000 on the felony and $2,500 on the misdemeanor. Your total bond is $7,500 cash or surety. Mr. Griffey, your bond does have a condition of random urinalysis. So if you post bond, be aware that you can be drug tested at any time, and likely will be drug tested when you get to felony court. Normally Judge Garcia does drug test individuals down there. So you've got a $7,500 bond. You'll get to use the phone in just a few minutes. You can go to a bondsman if you wish. And I'm also going to ask the jail to give you a notice for your court date before you leave the jail. That court date, Mr. McDaniel, do you have that?
November 4th.
Yep.
November 4th at 8:30 will be the notice they give you, Mr. Griffey. You will not be mailed a notice from the clerk's office. That notice the jail will put in your hand will be the only notice you get. Do you have any questions?
No, sir.
All right, wish you the best, Mr. Griffey.
Morse.
We have Morris Bates next. Mr. Spates, good morning. Mr. Spates, you're here. It's like you first appeared this weekend and you were brought back up today so I could try to get you arraigned in the VOP, I believe. There's already a VOP filed, so I'm going to go ahead and arraign you in that VOP. Also, you've been made an offer in the new misdemeanor charge. So let me get you arraigned in the VOP first, and then we'll see where we stand in the misdemeanor case. Would you like me to go ahead and get you an attorney appointed in the VOP, Mr. Spates?
Yes, sir. Go ahead, Your Honor.
Mr. Spates, I'm going to appoint the public defender's officer to represent you in the violation of probation. So let Mr. McDaniel give you a court date in that charge, and then we'll see if you have any questions about that, and we'll move on to the misdemeanor. Mr. McDaniel?
Your Honor, we're going to plea of not guilty as. Yep. Your Honor, we're going to plea of not guilty as to set this on November 6th pretrial docket. I've already advised Mr. Green, advising Mr. Green to come by and visit him prior to that hearing.
Okay, Mr. Mitchell, anything on the VOP?
No.
Mr. Spates, any questions on the VOP?
No, sir, none at all.
All right, good deal. So let's see what we stand in the misdemeanor. Mr. McDaniel?
Your Honor, I spoke to Mr. Space. He's going to plead of no contest to resistance without violence. Understanding he'll be sentenced to 6 months in the county jail. He'll have 1 day jail credit, $370 fine. He has waived his waiver to a jury trial and called witnesses at that trial. Jake, I don't know if this is your case or not, but I mean, you know, if y'all were trying to work out some kind of jail sentence on the felony case, I mean, I think that's probably what we want to do on that felony case.
Yeah, I think it's going to be my case, so I'll see what I can work out.
So recently the state has changed the assignments, which is really good because Mr. Mitchell probably will be your VOP prosecutor. And that'll help Mr. Spates because he'll see that you've got jail time in the misdemeanor that caused the violation. So now that you got the same prosecutor, Mr. Mitchell, I'm not saying what he'll do, it'll be his call, but he'll at least know that you got him misdemeanor jail sentence, and he'll know that misdemeanor was the sole basis for the VOP. Now, there's a lot of other factors he'll look at, like how long you were on probation before you violated, how serious the charge you were on probation for. So there's other factors, but it'll make things a little smoother, I think. So as far as resolving the misdemeanor with that plea that your attorney put on the record, Mr. Spates, is that the plea that you want to enter?
Yes, sir.
Mr. Spates, I'm going to accept your plea of no contest to the charge of resisting an officer without violence. I'm going to judge you guilty of that offense, sentence you to 6 months in the Jackson County Jail. You got credit for 1 day, $370. Court costs and fines are imposed. Mr. McDaniel, do you want that standard language on the plea form that the plea will not be used against him?
Yes, Your Honor.
Make a note, please. If the plea itself will not be used against you, Mr. Spates, that doesn't they still can use the incident. They just can't use what happened here today against you because we want to keep your cases moving. So if Mr. Mitchell and you don't reach an agreement that the judge accepts in the VOP case, they'll have to call witnesses to what supposedly happened. They can't just introduce a certified copy of a plea from today to violate your probation. Mr. Spates, do you have any questions?
No, sir.
Mr. Spates, wish you the best, sir.
Thank you. You are blessed.
You too, sir. So Mr. Jackson, we've already seen, I did a 7-day hold. The next case then is Scotty Thornton. Mr. Thornton, good morning. Mr. Thornton, you're here because you've been accused of 1 count of aggravated battery. Mr. Thornton, I think the weekend judge saw you but passed you to today probably because of the background of the case and that this was a case that allegedly occurred at Sunland. Let me see if the attorneys have any additional information before I set your bond and make a decision on what to do. Mr. McDaniel?
Yeah, just that he does have some, significant medical issues. That's why he's got a helmet on and, just take those things in the best of the court can consider.
Thank you, Mr. Mitchell.
Your Honor, I think right now what the state would be requesting is that we be given some time to find out what the status of his commitment at Sunland is, and then see if we can contact someone with DCF or APD to see how we proceed with this case. I know it's not going to be my case if this does go forward, but I'll talk with Mr. Gill or Ms. Jeffcoat.
Thank you. So, Mr. McDaniel, we haven't had one of these Sunland cases in a while. I think what we started doing is setting him a bond. He's entitled to a bond. Mr. Thornton, you're entitled to a bond. I'm gonna go ahead and set your bond. You're accused of a 2nd-degree felony, so your bond's gonna be $15,000 cash or surety. Mr. Thornton, you do have a hold. I can't tell from the complaint if that hold is with APD or DCF. It's either Agency with Persons with Disabilities or Department of Children and Families. You have a hold from one of those agencies. So what I'm going to do is I'm going to ask the jail to bring you back in 1 week if you haven't posted bond. If you posted bond, you'll be released to that agency and they'll decide what to do with you. If you don't post bond, I'm going to see you in 1 week. I'm going to ask Mr. Mitchell to communicate with those authorities of those appropriate agency within that week. As a general rule, Mr. Mitchell, we found that most of the time, not always, but most of the time, these individuals don't need to be in jail. They need to be somewhere else. Okay. It just takes time to figure out where that place needs to be. So I will consider any reasonable other options once you've had time to look into it and tell me what the recommendation is. Sometimes they need to be moved to a more secure facility, and it just takes time to do that with the original county. So, Mr. McDaniel, I think that's the way we've handled it in the past. We've given them some time and we've reviewed it again. And at that point, I'm considering some type of release possibly on the new charge, but I've got to make sure we've got some other placement option in place. And I think a week is plenty of time to do that. Mr. McDaniel, any other input to that process I'm thinking of following?
Just, I don't know. Is Waylon still the attorney for APD or,
No, Waylon, Mr. Lewis is now the general counsel for the 14th Circuit. But he's extremely knowledgeable. So Mr. Mitchell, the general counsel for the 14th Circuit, Waylon Lewis, was the attorney for DCF and APD or Orb APD. So he's very knowledgeable. I don't know who the attorney is now, but Mr. Lewis, who's with court administration, is an excellent resource because he was the attorney that did this stuff before. So if they don't have an attorney hired yet, he's probably been gone 2-3 months. If they don't have an attorney hired yet, he'd be a good person to reach out to explain the process.
Okay.
Mr. Thornton, do you have any questions?
He don't have any questions, Your Honor.
Okay. I'll see you in 1 week, Mr. Thornton. Next case is Shelby Cook. Mr. Cook, good morning. Mr. Cook, it looks like you were first appeared this weekend and you were set bonds, but it looks like you've got a violation of probation and the judge, I think, had you brought back to see what we wanted to do with that. Mr. Cook, similar to the way you've seen other cases, we give them 7 days. I'm going to put a 7-day hold on you for possible violation of state probation. I'm going to ask Mr. Mitchell to notify the authorities, the probation office, of your arrest, and we'll see if they have a warrant within 7 days. So I'll see you next Monday, Mr. Cook, and we'll see where we stand. Do you have any questions? Have a good day. Is this Mr. Kirkland?
Mr. Kirkland, Your Honor. Mr. Damaris, we're just going to ask the court to set a bond on this. He's got some issues, and I think the jail is discussing with Judge Garcia what to do with this particular person.
Okay.
He's not able to come out. He's
on Alexander Damaris, the battery on law enforcement, on firefighter or EMT. There is probable cause. Mr. Mitchell, any input on bond?
No, Your Honor.
I'm gonna set a bond of $5,000 cash or surety. But there may be other release options. I don't know that going back to that same facility he was in is the best thing. I'm not going to let that happen without some more input. So, Mr. McDaniel, if you work out another placement, let me know, and he may be a conditional release candidate next few days.
Thank you, Your Honor.
Or if going back to that program, if they want him back there, I need a lot more information on that before I would let that happen. I think the police officer was the actual alleged victim in that case, but it looks like there was a lot of problems at that home, so I don't think I let him go back to that particular home. Then we have Sandor Kirkland. Mr. Kirkland, you were held 7 days to see what happened with the battery violation of probation. I looked at that this morning. The warrant was in Judge Garcia's queue. It was submitted sometime later, part of last week. And based upon the injuries to the alleged victim, I went ahead and signed that warrant. So you've got a no bond warrant for violation of probation. So what I'm going to do this morning is I'm going to go ahead and get you arraigned on that violation of probation, because I want to get you on the next court docket and get you an attorney appointed. And the injuries were the reason I signed the warrant. If it had just been a he said without any injuries, I would have called Judge Garcia, or I would have went ahead and issued a warrant with a bond on it. But because of the injuries, I did not do that. Mr. Kirkland, would you like to have an attorney appointed to represent you in the VOP?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and then we'll see if you have any questions in the violation of probation charge.
Your Honor, plead not guilty. Asked to set this on November 6th pretrial docket. Advising Mr. Green to come by and visit him prior to that hearing. Also, I don't know, they had actually, I guess the clerk's office put him on the Hispanic day. He's not an Hispanic day. I don't know if we want to put him on the jail docket, I guess, maybe or on the October 27th docket.
Yeah, and now that this has happened, I think that's what we need to do, Mr. McDaniel. You agree, Mr. Mitchell?
Yes, Your Honor.
Mr. Mitchell, anything on the VOP charge?
Nothing on the VOP.
So on the VOP, November 6th will be your court date. Mr. Green will come see you before then. In the other case, the jail docket date, do you have that, Dottie? Or Mr. McDaniel, do you know the jail docket date?
5th or 12th, one of the two.
I've got it here somewhere.
November 12th.
So we'll see you on the 12th unless you resolve it on the 5th, Mr. Kirkland. When you go to court on the 5th, if you resolve the 6th, I'm sorry, if we go to court on the 6th, you may resolve everything. And if you do, now, so here's my question. This violation is based solely on a new misdemeanor battery. You're the prosecutor in the battery. Was that the type of VOP you'll have?
Yes.
So Mr. Mitchell will be the VOP attorney. So y'all may resolve everything on the 6th. If you do, then I won't see you on the 12th, but if this is still pending, I'll see you on the 12th. Any questions?
Yes, sir.
So, Josh, in Sandor Kirkland, I signed a warrant this morning. I need you to contact dispatch and see if they can get somebody to serve it at the jail today, please. I've already first appeared him on it, but we got to get the warrant out of the system. Okay. We had Mr. Booth. I talked to Sergeant Gross about that. I asked to see him if he didn't think that purge within a week to consider some other options, but I wasn't real clear. That's my fault. I meant a week from that first appearance date, not a week total credit. He had like 5 days credit. So I called Sergeant Gross this morning and said, if he hasn't posted bond within a week from when he pled, to bring him back up, and I'll see what the state's position is on doing something different than 30 days. I think it's the non-payment was the primary violation. There may have been something about not getting a license too, but was that it? Yeah, so I was hoping he'd make the purge, but if he can't make the purge, I'm not crazy about him spending 30 days in jail. I want to see what Mr. Mitchell's position is if he can't make the purge. That's everything I had on my list, gentlemen. Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Mr. Mitchell?
Nothing for the state, Your Honor.
Sergeant Grove?
All right, as he's finished up, let's go to Texas. We'll say good morning to Judge Stevens.
So here with Mr. Dusler, your attorney and the state's attorney here. There are two cases we're dealing with, as you probably know. In 21-38622, this is a motion to revoke unadjudicated probation where you were put on probation for the state jail felony of theft on January 6th of this year. Then there is another case, 25 CR 262, where you are alleged to have committed theft on or about November 23rd of last year, 2024. And because you have 2 or more prior theft convictions in county courts at law of Jefferson County, Texas, it's a state jail felony every time, even if it was a pack of gum. It's going to always be a state jail felony or higher, which means you're looking at up to 2 years. You get punished not just for the value of the property on a theft, but if you have prior theft convictions, then it's automatically a state jail felony. So that's just the way law is. And then we've got this other motion to revoke unadjudicated probation. That's pending. So what we do?
We're gonna deal with the notion of revocation.
All right. I need a pass and nothing but a pass. So help me God.
There won't be anything. It's unagreed to you, depending what you do on the motion to revoke, we'll take care of the civil case.
Okay.
So there won't be anything like that right now for the motion to revoke.
All right. Well, let's think this out. Then she has a right to appeal. Unless she hadn't waived it.
She waived the right to appeal.
No, on what I do here, she's gonna have to.
Oh, yeah,
but that's not been done. I mean, that's not done. But we're going through them, we're going through the proceeding, but then the normal paperwork that we include that not only has something to do with the defendant's rights, but also is a memorialization of what is on the record so that later someone doesn't go, I was confused. I didn't know what was happening. Nobody ran this by me. And then you have a signature in writing and all is well.
Once we dispose of the motion, what you decide what's going to happen with the motion, we'll do a waiver of appeal on the new case plus this and get it all for you.
Okay. Well, just, I trust you, but it's in the past, it's happened.
It'll be done.
Where that
It'll be done.
did not happen.
It'll be done in just
7
2 minutes.
Right, as I take a leap of faith here, in 21-38622, a motion to revoke unadjudicated probation has been filed in this case. You are Terry Lynn Broussard. Please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your does the defendant waive a formal reading of this motion to revoke unadjudicated probation in 38622? Can we proceed on summary?
Yes, sir.
And you were here with Mr. Dusler, your attorney, and the state's attorney is here. Ms. Broussard, in summary, this motion to revoke probation states that on January 6th of this year, earlier this year, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of theft. Is that true?
Yes, sir.
Okay. Allegation 1 here. After you were placed on probation, the motion goes on to state that you failed to report to the probation office, the Jefferson County Probation Office, on or about March 6th, March 12th, April 25th, 2025, in violation of your probation order. Is anyone from probation here on this? Okay, because I'm going to ask a couple of questions that, what happened? Where's?
I'm not certain, Your Honor.
I'm making a call to find out, Your
Because, I need just to verify, I think this is going to work smoothly, but still on the record, I'd like the probation office, because
I'll get them right.
they're the experts. Okay, this states that you failed to report on those dates in violation of your probation order. Is that true or untrue, ma'am?
Can you repeat that?
That you failed to report those dates.
You failed to report on March 6th, March 12th, and April 15th.
Somebody threatened to call on me and tell a bunch of lies. So my niece, we had got in a real big fight and this and that. So when she threatened to do that, because she's the one taking the feet to my.
But you didn't show up to
But
it.
I didn't show up.
All right. So that allegation would be true?
Yes, sir.
All right. Next, number 2 states you failed to immediately report to the probation office your new phone number. I guess you changed phones and you have to keep that updated, and That's a requirement of condition 9 of your probation order. Did you fail to do
I
that?
failed to do that.
Oh, but you're gonna fix that, right?
Oh, yes.
And finally, this states that you failed to provide verification of performing community service hours. Everybody on probation has to do community service hours. Did you fail to do
I
that?
failed it.
Oh. So are you stating that you, again, violated allegations 1, 2, and 3 of your probation order, failing to report, failing to immediately report your new phone number, failing to report the person, failing to immediately report your new phone number, and failing to provide verification of performing community service hours? Are all of those true and correct?
Yeah,
Are you pleading true and correct to those allegations voluntarily and because they are true as they are alleged in this motion?
yes.
Do you understand and appreciate that a voluntary and knowingly made plea of true to one or more violations of probation, that would be enough to grant the motion to revoke probation? Your probation can be revoked and you can now be sentenced up to the full range of punishment. This is a state jail felony, which carries with it no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today? Yes, I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. There was restitution owed, it looks like, in the amount of $119.70. Was that ever paid back?
One time I paid my probation.
Counselor, I spoke to her, that she's been testifying.
I haven't paid nothing.
You paid some of your fees, but they didn't.
Generally, it goes to fees first, and then what's left over goes to restitution. But it was $119.70.
That's what I'm supposed to pay once a month, $119.
But you never paid it. It never was applied since you were placed on probation.
Well, I thought I went in there and put some money down.
I know you put some money, but that's going to be for other types of fees.
Oh,
Every
okay.
probation officer, every probationer has to pay monthly fees for probation, kind of like they're paying for the probation. And what do we do about the restitution,
Yeah,
if anything?
if you keep her on probation, you know, you can continue to order it as you have. If you revoke her, just order the restitution as part of the sentence.
Well, the next question would be, how would you pay for it? How would you pay back the restitution? Do you have an income?
I mean, disability, I get $9.64 a month.
Yeah, but you still have to pay for your necessities of life, don't you?
Oh, yeah.
But do you have money left over?
Yeah. After I pay my probation, that's 120. And then all that's the rest of me. I had to pay rent, pay cell phone.
Yes, ma'am.
And pay a way to get back to work, which I do part-time. And I have food stamps. I get $200 worth of food stamps. I'm all good. $30 worth of hygiene.
All right, let's hold that just in abeyance here for just a moment. Let me go to this new case. This is a theft, state jail felony theft. Similar in to the previous case we were talking about, since she has 2 or more prior convictions of thefts alleged in each of these 2 indictments we were working on. Anytime you commit a theft, even if it's a pack of gum, it's a felony. What was the value on this theft in 25 CR 262? It looks like from Dillard's.
It was from Dillard's. There was a co-defendant. I think the aggregate was around $600, but everything was returned, to my understanding.
So there's no
restitution
on that one, right?
That's correct, Judge.
All right. Okay, now let's go back on 38622. What the court's going to, this court requires people to pay the loss back. That's how you fix it.
Okay.
Okay. So what I intend to do is revoke her probation, place her on regular probation. Okay. She has 94 days credit on this. So we put her on, convert it to a regular probation essentially for the purposes of getting the restitution paid back and hoping that this deters Ms. Broussard from stealing in the future. That's what I'm going to do.
Okay.
All right. Okay. Does the state need to present anything here? Because I think a knowing and involuntary made plea of truth that she's made under oath is enough to warrant the revocation.
Nothing from the state further.
Anything to add? If not, Ms. Broussard, what I'm going to find on this motion to revoke probation in 38622 is that you have pleaded true to allegations 1 and 2 and 3 of the motion to revoke unadjudicated probation with those violations voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation. Be granted by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. And you are hereby found guilty beyond a reasonable doubt of this underlying state jail felony of theft. In that original disposition on the plea hearing, you pleaded guilty to the state jail felony of theft in paragraphs 1 and 2 of the indictment voluntarily, knowingly, intelligently. That was enough to grant that, along with other documents supported your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony. You were hereby sentenced to confinement in the state jail for 2 years. That confinement will be suspended. You are placed on regular probation for 4 years. There will be terms and conditions of probation that have been normal and customary that you have failed to follow. Make sure you get it done. Most importantly, you owe restitution in this case in the amount of $119 to the standby. To the complainant, Jesse Ramirez, who I believe worked at HEB Pantry where this occurred. 3025 Dallin Road here in Beaumont, Texas. So can you pay that back? The quicker you pay that back and everything else is fine, I can then terminate this probation.
Okay. So in other words, when I
You
get
need to
it
pay your money back, and
Okay.
there, you got to serve a third of the
Okay.
time, but once you do that, we can get this off your back and the probation office can move on to other clients. All right. Now we go to 25 CR 262. What are you going to do now?
We've just sent to her a agreement for pleading guilty. Same thing, 2 years, probate for 4 years from.
No, I'm not going to do that on this. Is
Whatever.
there any restitution here?
There's not
No
restitution.
Signs with it.
Okay.
Okay.
Whatever he feels appropriate.
What is her credit on 262? Is it 94 days on 216? Because I was going to just do time served.
Okay.
Yeah, it's 45 days, Judge. The one before she had credit before she was placed on probation. So that was-
All right. All right.
So she only has 45 days.
That would have to be.
Cool. So we'll do. Okay.
You'll just change.
That's what I plan to do.
You just change that on people.
Okay, y'all get those done?
We've already sent the
It's not-
paperwork,
Oh,
Judge.
okay.
You can just change it on the plea bargain agreement or on the will.
We did it under the terms of probation, so it just needs to be changed to 1244.
Yep. Twenty-five CR 262 is now called the State of Texas versus Terrellyn C. Broussard. That's you present with Mr. Dusler, your attorney, and the state's attorney, Dust, the defendant. We have a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, sir.
In summary, ma'am, this indictment alleges in paragraph 1 that on or about November 23rd, 2024, going on a year, you committed theft at Dillard's of a value of less than $2,500, and it looks like it involved some items that when you were stopped leaving the store, they recovered.
Okay.
Or was it's
Believe it-
generic,
Various items of.
various items. All right, did you commit theft that day and were arrested? All right, yes. Paragraph 2 goes on to allege that you have 2 or more prior convictions of thefts in 2002 and 2018 out of courts of law 3 of Jefferson County, Texas, and county court at law 2 of Jefferson County, respectively. Is that allegation or those allegations true and correct that you have previously been convicted of thefts
Yes, sir.
on those times? So paragraphs 1 and 2 will constitute a state jail felony with 2 or more prior theft convictions in courts of law that are a county court at law or above in jurisdiction. Then when you just, any kind of theft is automatically a felony.
Okay. So in other words,
So
telling me,
you're facing no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range you are looking at? By pleading guilty to paragraph 1 and true to paragraph 2 in this state jail case. Stand by. So you're gonna have to, this is gonna be a little awkward, so just work with me here. The agreement's been reached where your punishment of the state jail felony will be reduced to a misdemeanor punishment under section 12.44 of the Texas Penal Code, which states that a court may punish a defendant who is convicted of a state jail felony, which you're about to get convicted here on this, by imposing confinement permissible as punishment for a Class A misdemeanor, which is up to 1 year in the county jail. After considering the gravity and circumstances of the felony committed and the history, character, and rehabilitative needs of the defendant, the court finds in this case that such punishment under section 12.44 of the Texas Penal Code would best serve the ends of justice under these particular case. Under this particular case, you have 94 days credit. So still have to, there's still going to be some well, it's, yeah, I'm just going to give her the credit that she served. 94, that's what we're looking at.
Judge, I believe it's around 40 in this case. The 94 was for the motion to revoke case.
She said,
Yes, 45.
45.
all right, and that's what it will be. That's let's fix all this. Misdemeanor punishment. You say 45 days?
5 days.
If I follow this agreement, you have no right of appeal of your case. Do you understand, ma'am?
Yes, sir.
How do you plead to this state jail felony here in 25 CR 262, guilty or not guilty?
Yes, guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes. Mhm.
I showed you what's marked as State Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. In this indictment, you have you're pleading guilty to allegation 1, paragraph 1, which is illegally appropriating or stealing clothes of a value of less than $2,500 from Dillard's. Is that correct?
Yes.
And then paragraph 2 alleges that you have 2 or more prior theft convictions out of the County Court at Law 3 and County Court of Law 2 of Jefferson County, Texas, theft convictions in 2002 and 2018. You have pleaded true to all of that today. Paragraphs 1 and 2 constitute a state jail felony, which means you face no less than 180 days up to 2 years in state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And furthermore, the agreement has been reached in this case that you would be found guilty of this state jail felony in 262, but punished as though it were misdemeanor punishment pursuant to a state jail felony conviction, which is allowed under section 12.44 of the Texas Penal Code. Do you understand?
Yes, sir. Mhm.
If I follow all of this, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead then to this allegation 1 of theft of property from Dillard's, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? And
Yes.
paragraph 2, which alleges those prior convictions of thefts out of County Courts at Law 3 in 2002 and County Court at Law 2, both of Jefferson County, Texas in 2018, are those thefts alleged that you committed all true and correct as they are alleged, and are you pleading true to that voluntarily and because those allegations are true?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Everything is true and correct. State's Exhibit 1 tendered into evidence and without objection. Among other things, this states you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You understand what you're charged with. You're guilty of the crime charged than any lesser included offense. And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports waived.
Yes, sir.
In 25 CR 262, if nothing further, Ms. Broussard, I'm going to find you are pleading guilty to paragraphs 1 and 2, which constitute the state jail felony of theft. You were doing this voluntarily, knowingly, intelligently. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of the state jail felony to support your guilty plea. I now find you guilty beyond a reasonable doubt of the state jail felony. However, in accordance with this agreement, you are going to be punished as though this were a misdemeanor punishment of Class A misdemeanor up to 1 year in the county jail. You were hereby sentenced to confinement in the county jail for 45 days in this case. This sentence shall run concurrently with the other sentence in 1386222. Now, even though you're punished as though it were a misdemeanor, it's still a state jail felony conviction. That's not good to have. You have to be careful and follow the rules.
Yeah.
Will you do that? Promise? Oh, okay.
I promise.
All right. This should finalize this case. I'm going to be placed on probation here on this other one and get that restitution paid back as soon as you can. Okay, ma'am? Thank you. Anything else?
Huh?
I just need to use your thumbprint on you, please. Right thumbprint? No, right thumb, yes, ma'am.
Okie dokie, let's change it up a little bit. We'll go to Wisconsin, see what's going on with Judge Mogan this morning.
We will go on the record in the matter 25 CM 148 25 TR 542, State of Wisconsin versus Jaden Daly. The state appears through Assistant District Attorney Jose Vila in person. We have Emma Hunu, Defense Counsel, in person with Mr. Daly. We're set today in this matter for status conferences. Ms. Hanu, please update the court.
Thank you, Your Honor. Before my appointment, an offer was made on the record. I reviewed that offer with Mr. Daly. That offer would be to plead to his open OWI first that I do not represent on, as well as drop the current matter, the possession of THC, to a site of an ordinance. He would like to accept that offer.
All right. And Mr. Daly, you understand the offer. It is to amend the THC as a misdemeanor to an ordinance violation. You understand that?
Yes, Your Honor.
And do you understand, or it's my understanding that you wish to plead guilty then to that ordinance as well as the OWI first ticket?
Yes.
Okay. And you had enough time to go over with your attorney, your criminal rights, your constitutional rights, as well as the facts of the case?
Yes.
Okay. And you're at Kemp Road in Siren?
Yes.
Telephone ends in 7537?
Yep.
Okay. As to the THC, formal motion to amend?
So moved.
Granted. How do you wish to plead?
Guilty.
The court will accept your plea of guilt. As to the OWI first, how do you wish to plead?
Guilty.
The court will find your plea of guilt in both matters is done freely, intelligently, and voluntarily with having counsel to represent you. Are you currently employed?
Yes.
And where do you work?
Jersey Mike's.
Excellent. Well, that's not even close. Is it close? It's not even close to here.
It's in Eau Claire.
Okay. You don't. So are you in school?
No.
You just drive there?
No, I stay with my brother while I work.
Okay.
But I still live at home.
Like, that's a very far drive
Yeah,
to
I
go
know.
work at Jersey Mike's. Good sandwiches, good subs. But, okay. And so with regards to the OWI first, that would be $1,037.50 and a $10 blood draw fee. Yes. Oh, that's right. It's an OWI. Usually we have a different clerk who does the OWI, so our system, it's not easy to understand.
I know.
So just how much, Levy? I'm sorry.
$1,037.50.
All right, thank you.
$10 blood draw. 6-month revocation of your driver's license, 6 points on the license. If you want to get some points back, there's a class that you can take and you can earn up to 3 points to get those back or removed or whatever. With the THC ordinance, I'm only going to assess $200. I'm waiving the rest because you're already getting hit pretty hard with that OWI first, okay? How much are you able to put down?
None at the moment. Is there any way I can make payments?
You certainly can make payments. I'm going to need at minimum $200 a month.
Okay.
Okay. And so all the notices are going to go to that Kemp Road and not your Eau Claire unless you want to change it.
No.
Okay. So here's the deal. You have to make your first payment. I'll let you make your first payment in November.
Okay.
And so you can have some time to be able to come up with it, but you have to make sure you make that payment every month. If you want it to be taken directly out of your checks, you can go see the clerk right out there. You can see Amy and she'll make sure she does a wage assignment. Then you don't even have to worry about it. You don't need to, go, oh my gosh, I forgot to pay, because not only will I enter a civil judgment against you, but you could sit up to 6 months in jail and I'll issue a warrant if I don't get your payment. So it's very serious. So if you think it's easier for you to have it taken out of your check, stop right at the window, talk to Amy, she'll get it done.
Okay.
Okay. Again, first payment in November. I don't need DNA. I don't need anything. I think we are good to go. You got everything? Excellent. All right. So you don't need anything from our clerk up here. All you need to do is go see Amy and we're good. Okay.
Alrighty. Thank you, Your Honor.
Lee Moritz. We will go on the record in the matter 25 CM 113, 25 CM 185, State of Wisconsin versus Lee Moritz. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Moritz in person without counsel. We're set today in these matters for an initial appearance in the 185 case and a status in the other. Mr. Moritz, did you receive a copy of that new complaint? And that's what it looks like in your hand.
Yes,
Did you read it?
I didn't read the whole thing.
But do you understand that charge and that maximum penalty?
I really don't.
Okay, well, it's easy. I'll just go over it with you and you'll totally understand. It's alleging that on or around June 13th, 2025, you knowingly, you did so understandingly, that you violated an injunction, which is a restraining order, as people know it in lay terms. An injunction where you're not supposed to have any contact at all in any way, shape, or form at all with an individual in 24 CM 120. So they're alleging on June 13th, 2025, you violated that, you broke the law, you had contact. Don't say a word. You could, upon conviction, you could be fined not more than $10,000 and have incarceration of not more than 9 months in jail. So that's that maximum penalty associated with the charge and what the state would have to prove. Okay, and it's alleging that you did have contact, you knew you had contact, and you knew you weren't supposed to have contact with that domestic abuse injunction. Okay, I would not say any facts about the case because anything that you say here today can be used against you. Okay, but if you have a question, an administrative question, I can answer that.
I spoke to Jose and he didn't help me at all. I had a lot.
Not supposed to. He's the state. He's on the opposite side.
Oh, I see. I don't know how this works.
Okay.
I have no idea how this works.
He's the attorney that prosecutes you, that he's wanting to protect the public interest and the allegations in both of these complaints because they're very similar. So he's not the guy who can help you.
Oh,
if you're
see,
looking,
I don't understand how any of this works.
Okay. So
I don't have enough money to buy an attorney right now. So
did you talk to, there was a gentleman, and I'm going to try and find somebody outside who can stop. Hey, why don't you please, one of you run out, Mr. Flisky's right outside, and then we can get Mr. Flisky so he can talk with Mr. Morris to see if he qualifies. Thank you, Ms. Bauer. You talked to him already?
I talked to a woman the last time I was here.
Okay.
And I don't
Apparently we
qualify.
don't need him.
I don't
Apparently
qualify
he doesn't
at all.
qualify. So, but thank you, Ms. Bauer. Okay, so you don't qualify.
Well, she
Okay.
told me I can only make like $200 a month, and
No, it's not that. It's not $200 a month. It's like you probably own property. If you own property.
I do.
Then that's what
I
that's
own
what cut you
quite
out.
a bit of property.
So what you would probably like to do is retain your own attorney or apply for a court-appointed attorney, but that's still at your cost and you'll still need to have money down. But if that's the route you wish to go, then you need to go outside and get that application when we're done here today. Fill it out today. It can't be any later today because I'm not going to wait until the next hearing to have you go, oh, I didn't do it. So you have to go fill that out today if you want a court-appointed attorney at your cost. It's $100 an hour, but that's far less than the other attorneys. You can pay $300 or $400 an hour for a private attorney. You can go that route too. That's totally up to you. But otherwise, it's a reduced rate at $100 an hour. Having these cases, you would need to pay $350 down.
I don't have any money, Your Honor.
Okay, so at this time, you're representing yourself and that's fine and you can do that. Not guilty plea is going to be entered on your behalf on this charge as well as the last charge. But Mr. Villa, you're not his attorney. You don't represent him. He tried to talk to you about the case, but so with regards to this matter and your boots that you fill, what is an offer that can be presented?
Your Honor, at this time, I cannot present an offer. We have further cases that are coming down the pipeline, so I'm going to do a global.
Okay, so there's more referrals of the same-ish thing?
Yes, Your Honor.
Okay, so you can understand, Mr. Moritz, that from what Mr. Villa is saying is that there are more allegations of you doing the very same thing, and it looks like more charges, more cases are coming down the pike, okay? So
it's all Greek to me.
all I can do is, all I can say is I can strongly advise you that you need to not have any contact, not only because it's criminally hurtful, but because you have a domestic abuse injunction. 0 contact with BR. 0 contact. No texting, no talking, no swearing, no pushing, no third party contact unless it's through an attorney.
Can I talk to you?
I may not be able to give you any answers.
This is my situation.
I don't know if you want to tell me your situation because again,
I want to. I want you to understand.
everything, I can't understand. Everything that you say can be used against this gentleman right over here, and he can use it, and he can use it even if it hurts you.
But I need to talk to her because she did all my business work, all my taxes. And I need some documents from her to get,
Can't.
but I need that and she will not give me, that's why I keep,
I would stop. I would stop right now because the
I just
law
don't
says-
understand what's happening. I don't. I didn't abuse anybody. I've never abused
Here's the
anybody
thing,
in my
but
life.
there is a domestic abuse injunction.
That's it's false allegation
Well, it's in effect.
because she came to the court first.
I am telling you right now,
To
I'm
shut
not going to
up.
go look at the case. I'm not going to look at the facts. I'm not going to do those things.
Well, someone needs to.
There is in effect a domestic abuse injunction that says absolutely 0 contact, none whatsoever. No text messages, no calls, no thinking hypothetically or not hypothetically, thinking towards her, no talking to people, not trying to do anything that has any contact with BR at all. Not at all. And if you need contact, you want to know, it says in the injunction, I can tell you right this because it says in the injunction, you can have 0 third-party contact unless it's through an attorney. So that's your option.
I don't have any money, so I don't, my life's in your hands, Your Honor.
It's not in my hands. It's in your hands because I don't make the choices and I don't have the conduct you do. You're the one who understands what the law is prohibiting and you continue to do it the only way. And through that injunction, it says attorney. So what you're going to need to do is I'm strongly advising you at least you can go hire an attorney for this one sole little thing.
I don't have any money, Your Honor. I don't. She took $25,000 from me and split.
I don't know what else to tell you.
I don't have any money, so I don't want to go to jail. I don't know what to do.
I would stop having contact with BR.
But I need some paperwork from her.
And I told you how to
need
do it. I told you how
I
to
can't
do it.
afford an attorney, Your Honor. I'm at your mercy.
There's no mercy here. I cannot be merciful. I have nothing that I can do right here at this time. An injunction says 0 contact any way, shape, or form.
I understand.
Except through an attorney. So you know the
I understand.
fix.
I understand.
And you have the fix. You just have to figure out, problem solve to get to that, to be able to get what you need. I can't give you authority to do that.
I understand.
So what I'm going to do, how long do you think it's going to take you to review these new referrals?
Your Honor, less than 30 days.
December 10th at 9:45, December 10th at 9:45. We're going to have the next hearing and that's a status and most likely it's going to be further initial appearances. Again, all I can say is from the injunction, Mr. Moritz, and I'm trying to tell you your path and the thing that you can do. You need an attorney to just have that communication. And I know you say you don't have money, but here's the thing. Have you talked to an attorney to see how much money it'll cost just to have that communication?
$1,500 retainer.
Well, how many attorneys did you talk to?
Benson.
Oh, one. There's multiple other attorneys to talk to that don't charge $1,500 retainer just to send a letter to try and get business documents. There's more than one attorney in the world, okay? As you saw, we had at least 4 in here today. not counting the state. Mr. Vila.
Your Honor, it does appear that we also need to set bond for these cases.
All right. The court is going to do $500 signature bond. Okay, $500 signature bond. Absolutely no contact with BR or residents.
I have a question.
Yes.
What does a signature bond mean?
A signature bond means you're going to sign the bond. You're going to understand the conditions. You come to court, you follow the law, you don't break any of the conditions. And then if you do great and you don't violate any of those things, then you're fine. You're just signing by your signature. You're saying, I'm agreeing to abide by this. If you violate, not only can the court convert that to cash, well, they have to pay $500 bail, but the state has the ability to charge you for what's called bail jumping. Okay, you're
So-
charged with misdemeanor. So if you
So
violate
I
any
sign this
conditions,
bond, and if I don't communicate at all, I don't have to pay money? I don't understand.
correct. You don't violate the bond.
So
So you,
what, do I sign that today?
yes, you'll come up here and sign it right here today.
Okay,
I strongly encourage you to either find an attorney and retain that attorney, or to apply for that court-appointed attorney. Okay, and you'll fill out the whole application, and but I need proof of your income as well as.
I don't have it because I don't have the documents.
Don't need those documents. I just need you to tell me, I make this much, and this is under perjury. So I make
Okay,
this
but
much a
listen,
month.
I don't make a steady income. I've been self-employed since 1997.
I understand you used to cut our grass here. I
Yes,
understand that.
I did, and I lost my job because of this whole situation of false allegations.
Mr. Moritz,
I don't understand any of this. I've never been in trouble with the law.
here's the thing. You know people who know about the law. I know that. So go talk to people who know about the law. And either apply for a court-appointed attorney. That's an option right there. And you don't even have to say, I don't need to know, I make $100 this month, I make $300.
Well, that's the thing. It all depends on the weather. If it rains, I mow. If it snows, I plow.
You
If it
have an
doesn't rain or snow, I don't make any money.
You have an idea. You have an idea of how much you make, okay? You have an idea.
I don't make enough to pay my mortgage right now. It's been dry for 6 years.
Then it sounds like you could look at other employment opportunities as well. But here's the
I'm
thing.
49 years old.
I'm not going to argue with you.
I don't want to argue,
Then
Judge. I just
stop.
want to go home.
I gave you my options. You have those options. You need to choose one of those options because it sounds like it's going to get a little bit deeper because the state has more referrals. I don't know how many, but it could be 2 or more cases, 2 more referrals.
I text a couple times.
An injunction means no contact, none.
I understand. What if she contacts me though? And I'm not allowed to
You ignore
contact?
it.
Can you make sure there's no contact on the bond?
That's what I said.
Oh, okay. I just want to make sure.
So if she contacts you, you do not even respond. I can't talk to you because that's violating. Sounds like it's, kind of lopsided. Why can she contact you and you can't contact her?
That's what I don't understand.
That's the law.
See, I don't understand the law. I'm not a judge. I'm not a lawyer.
Block her.
But I need that paperwork.
Here's the thing. Again, the only reason why I
don't
know
want-
this,
I
the
don't-
only reason why I know this is because you brought your sister with you at the last hearing, that your sister's a law enforcement officer. You know somebody to talk to who knows the law. She knows the law. She knows the law. She's an officer of over 20 some years, maybe 30. She's an officer.
30 years.
So talk to your sister. And again, I only know that from the last hearing you were here. So you can't be trying to wishy-washy, tell me you don't understand the law, you don't know the law.
I don't.
You know an expert, a law enforcement officer. She can tell you all the things.
She doesn't. She's not a lawyer. She's a police officer.
Who knows the law. And if you say, hey, sister, I have a domestic abuse injunction against me with BR.
But
Does that mean I can't contact
The
her?
thing is, it's false allegations. That's not justice.
Okay.
It's all false allegations.
Okay, again,
Again, I just want to go home.
Correct. No, you don't want to just go home. You want to continue to argue and to argue and to argue and to argue and to argue. So stop, because I'm not going to do this again. You're getting your one time right now to have your voice be heard, and that's it.
Thank you for letting me be heard.
And I understand you have these issues, but I can't tell you what to do. Only an attorney can tell you what to do and how to go about it. I've given you your options,
All right.
okay?
Thank you.
So
Your
come
Honor.
and get your notice.
Thank you, Your Honor.
We'll see you in December. It's not a waste of time. It's my job. It is, and I appreciate that. Are you with him? Are you with him? Did I miss you?
It's 10 o'clock.
You do. Mr. Buskirk.
Right.
She said, "Are you with him?" But I envisioned it in my head as her saying, "Are you with stupid?" Man. She says it's her job, but there are days when your job is easier than others, and that wasn't easy for her. Let's go with a different pace. Michigan, Judge Middleton.
And it appears to be kind of a shove situation. Complainant ended up on the ground. She did state that Mr. Beller never struck her during it. This was a tumble to the ground kind of a situation. Mr. Beller's got quite a bit of jail credit already built up. So that's
32 days, according to my count.
We'd ask for time certified costs.
All right, Ms. Canfield, what's your input here?
Thank you, Your Honor. Respectfully disagree with the interpretation of the report. This indicates that Ms. Stewart claims that she was grabbed by the defendant and then thrown onto the ground. When the officer did observe her back through her tank top, she did have dirt and abrasions on her back from the incident. What concerns me more is that he's got a drunk driving conviction in 2007, domestic violence in 2017, attempted resisting and obstructing in 2017, and a possession of methamphetamine in 2022 that are all confirmed convictions. It appears he did go through a short period of probation in 2017, apparently that did not get through to him, did not put his hands on other people. So I would request, in addition to any credit for time served, that he be placed on probation with the domestic violence intervention counseling ordered as part of that probation to be completed successfully.
All right, thank you. Mr. Beller, anything you want to say?
No, Your Honor.
Mr. Beller does have a pretty extensive criminal history. A lot of baggage. Methamphetamine often underlies some of these things. We didn't get any victim input. I wasn't exactly clear of their relationship, but he did shove her down. She was dirt on her back. I guess the matter is open to interpretation. I'd hope to hear from her. I don't really want Mr. Beller on probation. He's already got a domestic violence conviction. He's homeless. I'm setting him up to fail. Mr. Beller, where are you going to go if you get out of jail?
Yeah, I've been, I'm already working with Pivotal, with Lauren at the jail. I already have a housing set up, actually, through Pivotal and that, and it's a friend of mine, which is a clean, sober home living, and everything. So, and it's not even in Sturgis, it's in Jones. So it's not even around there. So to keep me on the right track and continue moving forward on the right track and try to change my, past history of criminal history.
You and Miss Stewart don't have any children together.
No, sir. No, sir.
So you really don't have any reason to be together.
No. And this is where it draws the line, and I need to,
All right, 32 days of clean time and good food has helped you. But I'm just gonna, like I said, I'd hope to hear from her, but 32 days jail credit, 32 days.
Thank you, Your Honor.
I'm gonna order $125, which is the lowest I can order for 2 additional days, as I indicated. Maybe if you got this current situation, you could do a better job of probation, but you'll be living in Cass County. the nature of this tenuous relationship, and the fact that you spent a little more than a month in jail. You will get out today if you have $125. Otherwise, you have 2 additional days to do. You're good to go, sir.
Thank you, Your Honor. I appreciate it.
Thank you.
Sir, please just don't drink in public because I don't want to see you get arrested again, okay? Good luck.
Fairly short and to the point. Let's go to Judge Glazer. She's coming up on lunchtime. Let's see how she's doing.
Go right ahead. We have to check. Okay, you can check it. It's, yeah. Next, Carlo Gonzalez. I'm sir, you were arrested for resisting an officer without violence. I will appoint the public defender's office for you. There's cause for the charge.
Your Honor, he does have a prior recent.
I'm setting a bond, $500. Have a nice day. I can't argue. Next, we have Jakara Johnson.
On down.
Thank you. Christian Sanchez.
English.
Good morning, sir. You were arrested for reckless or careless operation of a vessel. Can you afford to hire a lawyer, sir?
Yeah, I defender.
No. Can you afford to hire a lawyer?
I can now, yes.
Then you don't qualify for the public defender. You're gonna have to hire a lawyer, okay?
So can I speak freely?
Don't talk about the facts. You're presumed not guilty. Just let me review it. So you're going too fast, causing a wake. That's the problem on his, it says he was speeding and spraying. Does he have any priors?
No.
I'll release you on your own recognizance. Listen, you're gonna ride a personal watercraft, you're gonna be responsible. Were you in the military?
Yes, ma'am. Yes, I
Come
was.
on, you need to know
No,
better. Make sure to get a lawyer. Keep all of your court appointments. You're not responsible if you're gonna be voting. Now you have to spend the night in jail. Okay. You don't want to be one of those people that's going and causing the wake and splashing people on it. Just go have fun. You know, and obey the rules of the water. ROR, have a nice day.
So there's a new obvious dynamic in Judge Glazer's courtroom, and that's that as the morning goes on, her audio gets hangry. I think it gets worse and worse. It starts out clear, and then it gets fuzzier and fuzzier and cuts out more. And I think audio doesn't have its breakfast before it goes live. I think that's the problem. Let's head back to Judge Stevens.
And you were Aaron J. Kimball, correct, sir?
Yes, sir.
Present with Mr. Dusler, your attorney and the state's attorney. We have 2 cases here. And this is 25 CR 1025 and 25 CR 1026, 2 indictments. In each of these cases, does the defendant waive a formal reading of the indictments and the arraignments? Can we proceed in summary?
Yes, sir.
Bear with us here, Mr. Kimball. In summary, 25 CR 1025 alleges that on or about July 6, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of obstruction or retaliation. And this looks like it involves threatening to harm another by assault in retaliation for the services of the victim who was a public servant, namely a Beaumont police officer. In 25 CR 1026, this goes on to also allege on or about July 6, 2025, you committed the offense of the 3rd-degree felony of harassment of a public servant. And it looks like it's the same complainant, the same victim. In one case, it's alleged that you threatened to harm him and his family. And in the second case, it looks like your saliva went onto the complainant, spitting somehow. So each of these are 3rd-degree felonies. Do you understand what you're charged with here?
Yes, sir.
These, the punishment range is the same on each case. You're facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? An agreement's been reached in these cases. You'd be pleading guilty and sentenced to 3 years, it looks like, in prison in both cases.
Yes.
And these would run concurrently. Is that your understanding of the plan?
Sure.
If I follow these agreements in each of these in each case, and this is the plan in both cases, if I follow these agreements, you have no right of appeal of your cases. Do you understand?
You understand? Yes. And you say yes.
How do you plead in each of these cases? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are indeed guilty of these offenses.
Yes. Yes, sir.
I show you in each of these cases what's going to be marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Are the contents true and correct? Okay, State's Exhibit 1 is tendered into evidence without
No objection.
objection. We got a problem here. Look at Aaron.
It's the tablet.
I know it is. Yeah. Here's what here, Aaron, this is what we need to do. I'm gonna give this back to you and here, work with me. I gotta do this myself. Put this thing right up over it because if you put your hand over it, it erases it when you're writing your name. You've got AR, we just need to get the other 2 letters. See, just add the other, yeah. Because if you put your hand on it, it erases what you're doing for weird reason. We're getting new tablets, my God, but we can't get them fast enough.
Okay. Yeah. Just on that page, all right?
Yeah, I think the others are good.
Okay. Oh, sorry.
Don, what you doing?
I was trying to lose it. And you'd like to.
Yeah, that's good.
This tab, this file, which is a different one. You get the start one.
And the way you normally write your name is you put Aaron, don't you?
Yes,
That's
sir.
the way you write. Looks like the president. He puts Donald. 25 CR 1026. Let me look at this real quick. Make sure. We gotta do the same thing.
Okay.
And in fact, it's
I just feel I was having trouble with my own signature.
Yes.
Yes.
I think, Aaron, you're gonna have to write, looks like 3 different times, yeah,
Okay.
on that one
Can you go
too.
ahead?
See, your letters didn't come out
That right
of, your
there.
AA comes out and then RON, but right on that, on that other
Yeah, you want
folder.
down a little bit.
Yeah.
Okay. More down.
God bless you. Powell.
Okay. Okay, I think that'll work.
That's not the only page.
Oh, it's
No,
sorry.
go scroll to the next page. I think we've got 3 pages.
Okay. Okay, I just need an end on that one. Wait a second. Okay. Now done more advanced, so it's exploded. Yeah, there it is. All right. I think we got it.
All right, so on each of these cases in 25 CR 1025, you understand fully what you're charged with, obstruction or retaliation on a public servant in 25 CR 1025, and harassment of a public servant in 25 CR 1026. These both were committed at or about the same time on or about July 6, 2025 in Jefferson County, Texas. And each of these are third-degree felonies, which carry with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed on each case. All of that, do you understand as being accurate? All right. The agreements in each of these cases, you would be pleading guilty, sentenced to 3 years in each of these cases. These shall run concurrently with each other. Is that your understanding of the agreements?
Yes, sir.
If I follow these agreements, sir, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Gotta change this to 025. What are we gonna get in the pass?
They've been ordered, Judge, but
Was it
yeah.
snail? Snail's bringing it over?
Well, we'll check the tracking.
That's good on that. Send this back to me. It was in this one. It's 25 CR 1025. Yeah, it came out, the 2 came out like a 7, and that's gonna, since it's running concurrently, we don't get the wrong case number. You gotta be put to the right case number so you get credit. Because it's 1026, not 1076.
Right.
All right, in each of these cases, 25 CR 1025 and 1026, Mr. Kimball, you have pleaded guilty voluntarily to these third-degree felonies. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea in each of these cases from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt in each of these 2 cases. I am following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years on each case, to run concurrently. Do you understand what has happened today, sir? All right, anything else to add? No, sir. That is it. Thank you very much. Thank you.
Okay, let's stay in Texas, but we'll go over to Judge Boyd and say good morning to her. Good morning, Ellie.
All right, so where are we on this case?
Your Honor, we have an offer and everything. However, I need a Padilla letter, so I'm waiting for the Padilla letter.
All right, so the Padilla letter has been out there since September, so.
I understand that, Your Honor.
So is this through the MAC?
Yes.
All right, Ms. Ferguson. Set this for a plea deadline date for the first week in November.
I think I'm the fourth.
All right, we're coming back on November 4th. Council, you need to reach out to.
I'm gonna reach out to them, and if I can get it sooner, I'll notify her that we did see.
All right, thank you.
Thank you.
Is there anything else?
That's it, Troy.
All right, do you have any questions?
No.
All right, thank you.
Thank you. I'll put that up on there.
Anyone else ready?
Sentencing on Ramirez. So that's over as well.
And what page is this?
Use page 8, one down.
All right, Alcadio Ramirez.
Pásale para acá. Puedes poner.
All right. So on this case, it appears that the state was opposed. Is that correct?
That's correct, Your Honor.
All right, so there needs to be a correction made to the plea bargaining agreement then, because it just says that the state is, it appears like the state is opposed to deferred adjudication.
I
it's-
thought the paperwork said there was no application
There's
for
no
deferred,
application.
then we're opposed. I just saw what was scanned in. Pardon me.
No, we didn't apply for it.
So it says there is no, right here, this is check, there is no application for deferred.
Yes,
And then
state
we're-
opposes.
Oh, they checked the wrong one. You're right, you're on.
Okay, thank you.
Thank
No
you.
problem. And Mr. Ramirez, do you understand that the state is opposed to your application for community supervision?
Yes.
All right.
Are you okay with me changing it?
No, that's fine.
Okay, I just initialed the place I scratched it out, Your Honor.
All right, the court is calling 2025 CR 0086662 State versus Alcadio Ramirez. Can I have parties announce?
Melissa Alvin for the state.
Hablar de Barça for the defendant.
And are you Mr. Ramirez?
Yes. Yes.
All right, so here's the thing. Either you're going to speak in Spanish or you're not. If you're going to speak in English, then I will excuse the interpreter. Do you understand?
Yes.
All right, do you wish to have the interpreter continue?
Yes.
All right, if the interpreter, if you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Good morning, Your Honor. My name is Catalina Delgado, spelled Delgado, license number 2222.
All right, we're here for sentencing. Have parties received the PSI and TAP evaluation?
That's correct, Your Honor.
I have your own.
Any corrections from the state?
No, Your Honor.
Defense?
Oh, yeah.
All right, you entered a plea bargaining agreement, Mr. Ramirez. According to your plea bargaining agreement, punishment is to be assessed at 5 years in the prison. There's $1,000 fine. You entered an application for community supervision. The state is opposed to your application. State, do you have any witnesses?
We do not, Your Honor. We just argue based on the contents of the PSI.
Defense, any witnesses?
No, you're.
All right, state, you're opposed?
We are opposed, Your Honor.
You may proceed.
Yes, Your Honor. As the court can see from the list of criminal offenses that this defendant has previously, this is his, I believe, 9th DWI. It looks like he was sentenced to prison 2 previous times for DWI 3rd. He could have been enhanced to a habitual offender and been looking at 25 to life, and he was not. Given this kind of overwhelming propensity for him to drive while intoxicated. I think it's clear he's a danger to the community and to society, and he should go to prison.
All right, defense.
Your Honor, I understand that he's got an alcohol problem. I think he understands that. However, he hasn't had any convictions or anything since 2013. This was an error. I think he takes responsibility for that. We're asking the court to place him on probation and transfer this to Del Rio, where he's gonna live with his inmates.
All right, if the court were to grant him his application, he would be going to safety. But any objections to the court reviewing the PSI or TAP evaluation?
Oh, yeah.
All right, so according to this, just 1 second, that shouldn't be in there. According to this, it says that guilt is minimized. What is that about? Oh, I'm so sorry.
I can't hear with the printer, Your Honor.
No. According to that, it says, according to the PSI, it says that he minimizes his guilt. What is that about?
That I don't know. Yes, you got that too.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Arcadio Ramirez.
Arcadio Ramirez.
All right, according to the PSI report, it says that you've minimized your guilt in this offense. Is that correct?
Yes.
All right, so counsel, one of the first things into giving someone help is they have to acknowledge that they need help, and it appears that he doesn't, according to him.
No, I do need help.
Help for what?
To get better from my alcoholism.
All right, but according to the PSI, you say that you were not drinking alcohol, you were not doing drugs or any of that in relationship to, in relations to this offense. So it appears that you don't need any help because according to you, there are no issues.
There is a problem. I can't say that I was very, very drunk. But I did have 2 large beers to drink, and that was all.
All right, any other questions from either side?
No, yeah.
I have some. Ramirez. You know you have a drinking problem, is that correct?
Yes.
You understand just because you had 2 beers, 2 large beers, whatever. That doesn't mean that you're seeking to minimize this. You understand you do have a drinking problem, right?
Yes.
And are you asking the court to help you in trying to solve this problem?
Of course.
You're asking the court to place you on probation? And also.
Yes.
She indicated that she wants you to go to safety. Do you have any problem with that? That's an alcohol in residential treatment program. Okay.
Okay, that's fine.
Is that what
Fine.
you'd like to do?
That's fine.
But that's what you'd like to do, correct?
Yes.
All right, this is where we are in this case. I'm looking at his criminal history. All of his criminal history is related to alcohol use.
Yes, sir.
And it appears that he was only placed on probation once for being intoxicated, and that was from 1999. And he was revoked and he was given 90 days in jail. And then he picks up another DWI in 2009, he had a DWI. And then 2013, he had a DWI and he was just sent to prison. I could send him to prison for 5 years. I don't know how much time he'd serve on a DWI. Normally on DWIs, people are doing probably about 4 years or close to the 5, but after he comes out, he's still going to have his drug or alcohol problem that he hasn't addressed. So I'm going to give you 2 choices. These are your only choices. Do not ask for anything else because you only have 2 choices. 1, I will sentence you to 5 years in the prison, or 2, I will place you on probation for 8 years. You are going into inpatient treatment, and that inpatient treatment is at the prison. Those are your only 2 choices.
You mean I'm gonna go to jail for 5 years?
Let me just talk. It's nice and-
All right, so here's the thing. Do you want prison or do you want treatment? Each one is going to require that you go to a lockdown facility.
The treatment.
All right. State, you may be excused.
Thank you.
The court is going to sentence you to $1,000 fine. That will be probated. The court will grant your application, sentence you to 5 years in prison, suspended and probated for 8 years. In custody, he is to be transferred to safety, and he's to remain in custody until transfer. And that's to be followed by aftercare. There's to be no driving for the duration of probation. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. And you said you wanted a transfer?
I believe you wanted, que querías ir a, como era del Río, ¿verdad? Sí. If you wanted to move to Del Rio, you're.
All right, transfer to Del Rio upon release from inpatient treatment. There's to be regular reporting by Zoom or in person, regular random UAs. $10 days in the Bexar County Jail as a condition. Ignition interlock for the full term. DWI education course. Victim Impact Panel Live. 90 sober meetings in 90 days upon release. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. When you are drinking and you're intoxicated, anybody can be killed. And what I've discovered is that usually the person who's driving intoxicated, they're just fine. They end up killing somebody else. If you do not take care of this problem and are serious about it, you're going to end up spending the rest of your life in prison. Do you understand?
Yes.
All right, good luck to you.
Barbara and Lady Jax, thank you both for gifting memberships. I appreciate that. Let's go back to Wisconsin and Judge Mogan. It was a little fiery there earlier. Let's see if it's calmed down or if it's more interesting stuff.
PM 142, State of Wisconsin versus Scott Buskirk. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Buskirk in person with counsel Joel Feliski. We're set today in this matter for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. There was an offer made in this case to resolve from the state that if Mr. Buskirk were to complete a DV education group course with Mr. Dave Hatch, the state would be willing to amend upon plea to the charge down to a citation. Mr. Buskirk had already begun that course, to my understanding, with Mr. Hatch in order to potentially secure an amendment to bond for the no contact condition. He's advised that he has one class remaining with Dave Hatch, so he is very close to completing the course and satisfying the terms of this offer. I have discussed that with him, and he does seem interested in taking the state's offer. So I believe that all that's left is to schedule for a plea and sentencing.
All right, and how quickly do you think that you can get the matter
Next week.
next week? I could do October 29th. Well, actually the 27th, 28th, or 29th. If you think you can get that all done by then?
Yeah.
And it's going to be an ordinance, you said?
That's my understanding of the offer, yes.
That would be, it would, with it being an ordinance, it's a prepay of $330.50.
Okay.
And so if you have that paid prior to and you give all the information to your attorney, you don't need to come back to that other hearing. We can just take care of it without you.
Okay.
But if you want to be here, you certainly can as well. I could do October 29th at 2.
Sure. That will work.
Okay, October 29th at 2. All right, so we will see you then.
Thank you.
Thank you. Yes. All right, 7919013. Is this Mr. Ainley?
Yes, ma'am.
All right, we'll be with you in 1 second.
Okay.
We will go on the record in the matter 25 CF 89, State of Wisconsin versus Timothy Ainley. The state appears through Assistant District Attorney Jose Villa in person. Mr. Ainley appears by telephone conference. His counsel, Zachary Fisher, appears by video. We're set today in this matter for a status. Mr. Fisher, please, or an arraignment, sorry. Can you please let me know if you went over the criminal information with Mr. Ainley?
Yes, Your Honor, I have reviewed the maximum, I have reviewed the charges and the maximum penalties. We would waive any formal reading or any further reading, enter not guilty pleas, and I would ask to set this for a status on December 15th at 2:30.
Did you receive an offer?
Yes, Your Honor, I have.
And what was that offer?
Your Honor, the offer is to plead to battery for a withheld sentence for 1 year of probation. I do just want to review discovery. Given that this was a felony, I have not received it since we recently had the preliminary hearing. So I just want to review discovery before we set this for a plea hearing.
All right, that sounds good. I cannot schedule it on that December 15th date because it needs to be on Mr. Villa's date. But I could do December 8th in the morning or December 10th in the morning.
I could do the 8th anytime except 11.
How about 9:45?
That works for me if that works for Mr. Ainley.
And
Yes,
he
sir,
can
that works
appear
for
by,
me.
okay, good. All right, so we will see you then 9:45 on December 8th. All right, thank you.
Thank you, Your Honor. Have a nice day.
We're adjourned.
Alrighty, let's go back to Judge Stevens. By the way, I'm keeping an eye on things in San Antonio. Not a Judge Boyd thing. It's a Judge Rangel who does not stream, but he's doing a trial for some officers in the killing of somebody named Melissa Perez. So I'm keeping an eye on that. It's not anything they're streaming. It's a local news station that's covering it. So Not quite sure what's going on there, but I'm gonna try to get up to speed on that case and see exactly what the details are behind it. But anyways, let's go back to Judge Stevens.
Sir, right over there. Thank you. She's gonna swear you in on some documents. Thank you.
Right there.
Mrs. Gavin?
Yes.
Swear or affirm, I will retrieve the whole truth, and nothing but the truth, so help you God. Okay, you got your right hand friend. Okay, place it flat, don't roll it. Okay, do it again. No. You get up again. There you go. Right. Do the same thing right there. Okay, you go stand in front of judge.
Here, sir. We now call 25 CR 1138, the state of Texas versus Gavin McMains. That's you, sir?
Sir.
Present. With Mr. Doodler, your attorney and the state's attorney, does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 27th, 2025 in Jefferson County, Texas, you committed the second-degree felony of robbery. Do you understand what you're charged with here?
Yes, sir.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. Is there a loss here?
That's what I'm looking at, Judge.
If there's a loss, you have to pay it back,
There
restitution.
was $800 worth of THC
Was there?
products taken. And
You know, you were there. Did you take something and keep it?
So like 3 things.
I know, but what were they?
THC vapes.
What's that?
THC.
Yeah, I know, but what is?
Vaping.
No, I'm talking about the value.
Oh, the
of
value.
those. I've,
He said 800.
According to the store owner clerk, they took approximately $800 worth of THC vape products and they destroyed a display which would cost about $700 to replace. So it's about $1,500 in restitution.
Is that your understanding of what happened, sir?
Yes, sir.
So it looks like you're gonna have to pay $1,500 back as part of this probation. And if you fail on probation, your probation could be revoked. You could then be found guilty and sentenced up to 20 years in prison. You don't want that, right?
Yes, sir.
Oh. So and we're gonna put you on probation here for 10 years, but I'll shorten it to 1/3 of that if you do well.
Yes, sir.
You gotta do well,
Yes, sir.
but overwhelmingly, most of the people on probation do. So there's no reason you shouldn't be that way. All right. So you're looking at deferred or unadjudicated probation, up to 10 years, fined $500, ordered to pay restitution, $1,500
Yes.
to the complainant in this case, which is the person's name in the indictment.
Judge, since he's juvenile and certified, we'll waive the fine of the 500 so he can pay the restitution. Concentrate on that instead of the fine.
Did you hear that?
Yes, sir.
Already getting a break.
It's just part of this. I get talk.
If I follow this agreement, sir, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this second-degree felony of robbery, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will,
Yes,
and
sir.
because you are guilty?
Yes, sir.
I'm going to show you the mark of State's Exhibit 1 here. Did you sign this document? Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No, sir.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is awaited here. Thank you for your prompt work from the probation officer, and I've got this wonderfully prepared probation order. If nothing further to add, I'm going to find in here, Mr. Gavin McMains, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But what we're going to do is defer any finding of guilt so long as you follow these terms and conditions of probation that the probation officer is going to go over with you. Make sure you do. That's your lifeline. You won't be found guilty of a felony offense if you do that. You don't need a felony. You know how long a felony you have to carry for the rest of your life?
Yes,
Yeah,
sir.
that's a long time. There will be terms and conditions of probation, which are normal and customary for this type of probation, including you will pay restitution in the amount of $1,500 to the victim. You do that, and that goes a long way to getting your probation shortened, and you get rewarded for doing well.
Yes, sir.
Please see the probation office, do well, and then do better,
Yes, sir.
and put this behind you. And,
Yes, sir.
okay.
You have a
Thank
good
you.
day.
Thank you. Thank you.
Yeah.
Ashlyn Wilson.
He's bringing it.
Wilson? Come here.
Sure, correct.
Raise your right hand for me. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, self is God. Okay. Each of you will right thumb print, please. Place it flat right there. You get up one more time. And then place it flat. Okay, you know, saying don't forget.
And we now call 25 CR 986, the state of Texas versus Ashton Wilson. That's you, Mr. Wilson? Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment, sir, alleges that on or about May 21st of this year in Jefferson County, Texas, you committed the second-degree felony of aggravated assault causing serious bodily injury to the victim. Do you, and it says you struck him about the head and body with your hands and feet. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 8 years in prison, and this sentence shall run concurrently, I guess, with another case that you already have, 24-1327. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, Mr. Wilson, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived here? Anything else to add by either party?
No, Your Honor.
There's an issue we hadn't talked about, but we need to talk about it. What are we going to do on the judgment as far as a deadly weapon?
Just
an
since there's serious
affirmative
bodily
finding.
injury, yes, since serious
Affirmative
bodily.
finding is going to have to be made.
That's fine because there was a deadly weapon finding on the previous case as well.
Okay, and this is going to be the deadly weapon here, or the defendant's hands and feet.
It won't change. Yes, sir.
All right. Okay, if nothing further to add, I'm going to follow this, Mr. Wilson. I'm going to find that you are pleading guilty today voluntarily to this second-degree felony of aggravated assault causing serious bodily injury in 25 CR 986. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault as indicted in 986. I'm following this agreement. You were hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit for all time you have served in accordance with this case. An affirmative finding will be rendered on the record in the judgment that a deadly weapon was used in the commission of this offense, namely your hands and feet. Do you understand what has happened today, sir? Anything else to add here? Okay, good luck for you.
All right, well, we wait for the next contestant there. Let's stay in Texas, but we'll go to Judge Boyd.
And are you Mr. Mishler?
No.
Thank you for dressing appropriately for court, but you always do. All right. On this case, have both parties had a chance to review the PSI report?
Yes.
Yes, Your Honor.
Are there any objections to the PSI report from either side?
I wouldn't call it an objection, Your Honor, but there has been a discussion about one of the lines where it said in the original PSR that was provided to the court, where it checks defendant accepts responsibility, he's pled guilty, that box was checked.
Mhm.
There was an addition made to it in court that said that Mr. Mishler declined to discuss the case, but when Mr. Mishler went to his interview, he did provide the PSR writer with the statement accepting responsibility. I've provided it to probation, I've provided it to the state, and with the court's permission, I've provided it to the court.
All right, any objections to the court reviewing it?
No, Your Honor.
All right, thank you.
Your Honor, I have an additional matter.
Yes.
There was a sentencing memorandum filed in this case about 5 days ago. After discussions with the state, we are withdrawing that document, that filing, and asking the court to sentence Mr. Mishler based on the PSR that's been reviewed by the court.
All right, and for the record, the court has not reviewed that, and the court does not review anything until everyone else has reviewed it and have no objections to the review.
I think there was a discussion as well as the court had asked us about a letter that the court received. We would also like you not to consider that.
All right, and the court has set that aside, and the court is not considering, nor has the court viewed it.
Thank you.
All right. So you entered a plea, and according to the plea, the state was proceeding on counts 1 and counts 10. They're asking that your punishment be assessed at a cap of 30 years in the prison. There's a $5,000 fine and there's no application. So the range of punishment in this case for you, based upon the plea agreement, is anywhere from 5 to 30 years. State, since neither party has any witnesses.
So Your Honor, actually, so count 1 is a range from 5 to 99 years. However, count 10 is a range from 15 to 99.
You're correct.
On that one.
All right.
We're gonna reserve our argument for after defense, Your Honor. We have no.
All right.
We have just argument, Your Honor.
Yes, you may proceed.
Mr. Mishler stands before you a broken man. He stands before you accepting responsibility for what he has done and the crime that he has committed. After reviewing the pre-sentence report and the police report in this case, Your Honor, you can see that he is ready to go to prison today for a significant amount of time. We'd ask the court to sentence Mr. Mishler to 15 years in the penitentiary. He is ready to go today. He accepts the court's judgment. And it's been a long road to get to this point, Your Honor. And we believe a 15-year sentence would serve the ends of justice in this case.
All right, State.
Yes, Your Honor, I have a little bit of an argument. So the state, Your Honor, is asking for the judge to sentence him to the maximum 30 years, Your Honor. This is a case involving a large hundreds, over 500 images of child pornography, Your Honor. We've included in our SIPs, these are not photos, these are videos. These are videos depicting the repeated sexual assault of children ranging from the ages of 18 and many of them ranging under the ages of 10 years old as well, Your Honor. Mr. Mishler admitted to having these child pornography images and videos, Your Honor, some of them of which are series of the same child in different videos being assaulted, Your Honor. The state's asking for the maximum, Your Honor. And if the court has the police reports as well, Mr. Mishler indicated that he got aroused by his 2 adopted daughters as well, Your Honor, that he would be aroused when they sit on him, when they're bouncing up and down on him, when he's tickling them, Your Honor. This is an individual who had these images not only on his personal computers at home, but had these images on him at a university campus as well on his work computer, Your Honor. This is a person who fostered children of ages similar to some of the ages in the videos that he had, Your Honor. And so we're asking that the court consider all of that and sentence him to the maximum 30 years prison, Your Honor.
All right, and this is what the court will do. Mr. Mitchell, I want you to know that I listened to arguments from both sides. I reviewed the PSI. I reviewed the evidence that was submitted, and I internalized everything. So I do appreciate the fact that you have accepted responsibility for your actions. That's usually the first step, right? All right, so this is what the court is going to do. Counts 1 and counts 10 are to run concurrently. There's to be no contact with minors. You are not allowed to reside in any household with minors. There's a $5,000 fine. Time and money will run concurrently, and the court will sentence you to 30 years in counts 1 and counts 10. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorneys? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. I know sometimes people will say, it's just a video, but the video is of people. And it's of people and of children being abused. And so to watch that is a form of abuse. Do you understand?
Yes, ma'am.
All right, good luck to you.
Your
Thank you,
Honor,
counsel.
I am, just so it's on the record, we need chapter 62 compliance as well, Your Honor.
All right, so according to this, and the reason why I didn't issue it, because usually you all will include that in the plea bargain agreements. So do you understand, I'm sorry, Mr. Mishler, can you raise your right hand for me, please? Okay, well, do you understand I'm going to take testimony from you, and it's just with regards to the chapter 62 registration, right? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, do you understand that this is an offense that will require you to register
I do.
as a sex offender?
Yes, ma'am.
All right. And knowing that that wasn't a part of your plea bargain agreement, I'm sure your attorneys may have discussed that with you, but do you understand by entering into this plea or having entered into this plea, you are going to have to register?
Yes, ma'am.
And knowing that, do you still wish to go forward with the plea?
Yes, ma'am.
All right, then the court will enter an order requiring chapter 62 registration. Thank you.
Thank you, Your Honor.
Thank
May I
you.
be excused?
Yes.
So he definitely needs to go away, and by no means whatsoever do I condone his crime. Far from it. But something that struck me while they were going through this was how bad does your situation have to be that you look at a plea for 30 years and you go, yeah, that's my best option. I can't imagine. Probably because I'm not inclined to do things that would put me in that position, but it's kind of crazy if you think about it. Wisconsin, let's go back to Judge Mogan.
3, 40, 25 TR 226 and 229. State of Wisconsin versus Charles Sprick. The state appears through Assistant District Attorney Jose Villa in person. We have Mr. Sprick appearing in person without counsel. We're set for initial appearance in one and statuses in the other. Mr. Sprick, there's allegations of a new.
Yes, I was gonna tell you about that. It's not because I was.
Don't tell me anything about the case, the facts, because it can be used against you. You gotta stop driving.
But how do it's just me. I mean, how do I take care of myself if I can't get around? But I'm gonna go tomorrow and get a work permit because
That's a first step.
they told me that I could get a work permit, and so that's what I'm gonna go do.
An occupational license, you can do that.
Yep.
Second thing is get your real driver's license.
Yeah, I know. Getting that ticket kind of bummed me out pretty bad.
So now we have allegations of a new one, so you understand that charge and that maximum penalty?
Yes.
Not guilty plea will be entered on your behalf. Mr. Villa, with the new one, is the offer still stand?
Following up on that now, Your Honor.
You were supposed to get your license, I believe, in the beginning of October.
Yeah, and I just been so consumed in everything going on with my new house and trying to get everything straightened out.
I know, but I'm going to tell you, I understand that.
I just spaced it out.
However, if these are crimes and you could sit in jail,
I know.
priorities.
Your Honor, the offer is to possibly get his license and dismiss.
So it's still there. Get
Okay.
your license and it'll be dismissed. But first
Okay.
things first, get your occupational.
Yeah.
Now, let's put that on over here. What do you have to do to get your full license now?
As far as I know, it was just to take the test, take the permit test again, and then I don't think I have to take the behind the wheel part.
Okay.
Because I think it says 8 years, then you have to, and it hasn't been 8 years.
All right. I'm going to give you one more time.
Okay, thank you.
And I'm going to give you December 10th
Okay.
at 9:30. December 10th at 9:30. I am going to verbally warn you and reprimand you right now. Do not get another one before December 10th.
No, I won't. But I'm off the record, but per se, like, isn't it like harassment when they see you, if they see you driving And that's what they stopped you for, is because they recognize you, not because you're doing anything wrong.
Hey, you wanna know, you are doing something
Well,
wrong.
yeah, I know,
And
but I
here's the
mean,
thing, they know your face, or
Yep.
they know your car, they know that Mr. Sprick isn't licensed.
Right.
That's not harassment, they're doing their job.
all right. Okay.
It's against the
I was
law.
just asking. I know it's against the law, but I was
It's
just
against the law. That's what they're pulling you over for. Get your license.
Yes, I am.
Okay.
I'm going to get my application.
Excellent.
Okay, thank you.
All right, thank you, see you later.
That was just precious. Yeah, I'm breaking the law, but isn't it harassment? I love it. Back to Judge Stevens.
All right, we're now calling 25 CR 225, the state of Texas versus Leon Damon Davis. That's you?
Yes.
Mr. Davis, with your attorney, Ms. Minaldi, and the state's prosecutors here. You are charged in this case with evading arrest or detention, and it is a state jail felony. You have paragraph 2, which shows at least four evading arrest or detention convictions. Thus, evading arrest, anytime you commit evading arrest, it becomes a state jail felony automatically. You are looking at no less than 180 days up to 2 years in the state jail, and the fine up to $10,000 can be assessed. Do you understand?
Yeah.
This last one was here in this court, right? In 2022, this last conviction?
That's what I have, Judge, from
Oh.
August of 2022. That one looks like it was a 3rd-degree felony, because it was with a vehicle.
Yeah. As you know, you are not eligible for probation here in front of a jury. You understand that?
Yes.
Okay, what was the offer on this?
A
What
year
was,
state jail, Judge.
ma'am?
A year state jail.
Okay, so that's, when can we get this tried? Because that's off the table, right? You don't want that. You've decided not to do that, right?
The enhancement, I didn't get the enhancement. I thought you gotta have like 3 evading detention.
You got 3 evadings.
One in the motor vehicle.
You got them all with the motor vehicle.
Motor vehicle. I had one, and I just had one, and I had one.
You got 2. I'm sorry, you got 2 with motor vehicles.
Yeah, and I thought you had to have like it's supposed to be 3
No,
evading.
2. No, 2 gets you. Yep, that's the magic number. When you got 2 that priors in something, you kind of get stuck from here on. That's why it's a good idea not to do this, because it's automatic. It's like people who commit thefts. If they have 2 or more thefts, if they steal a pack of gun, it's a gum, which is what, 50 cents? It's a felony from here on the rest of their life. Then it's similar to evading arrest. The law's treating it the same way. But what do you want to do?
They want to go to trial, yeah.
Nobody likes that. I know. But you're looking at up to 2 years. You understand that?
And Judge, I've discussed his options with him. I've reviewed the media with him. We're just at an impasse in terms of discussions.
You've
in regard to
got
that.
almost 100 days credit on.
That's not.
Oh, that's not yours.
So, but I can look at it real quick, Judge, and see what he's got.
You know how much credit you had, but we're going to figure it out for you so that it's working. It's accurate the way you think it is. It would have been January 11th, right? So
That's correct, Judge.
You've been in custody since January 11th? Yeah.
Go ahead, Jim. June.
He has 113 days credit.
How can you do that? Have you been in constant or custody since January 11th when you were arrested? Oh, okay, that's it. That's why.
At least one accusation, Judge, and then
Rearrested
rearrested. So actually,
June.
right.
in
So
June.
he's been in custody since June of 23rd of this year. Looks like he was in custody for 7 days before his accusation. So 113 plus 7.
Okay.
He's got.
All right.
120.
So where are we on this again? I think he's figuring out where he stands. Everybody's here. The prosecutor's here, the defense attorney, you. What are we going to do? You got an offer of 1 year. Is that what it is?
That's correct,
That,
Judge. And
you've
we've
talked to
tried
him about
negoti- Yeah, and we've tried negotiations and that's
what?
the hard offer and I've
Okay.
spoken with
All
him
right.
about
All right.
what.
He understands he can get credit for good time or good being good
Yes.
behavior, and where that what's this is a quarter, not a half, right? He's looking at parole in a fourth, 25%.
I think.
It's not an aggravated offense.
Right, but I think state jail just calculates a little bit differently.
Yeah.
I don't think it's a fourth, I think.
Yeah, everybody knows what it is, but I'm not. I'm not
But
clear
I mean,
about
I've been through all of his media with him. I have had discussions with
Okay.
him and anytime that I am attempting to advise legally, we come to an impasse. due
Okay,
to-
all right, it's his
you can't
choice.
Continue.
You know, you're looking at 2 years and, okay, and you're not eligible for probation here, so this is your choice, okay. That's what you want, set it for trial, sir?
Yes. Yeah, good.
All right, I want to get this as soon as possible. I don't want him just sitting around in jail. Let's get this done one way or the other,
And
okay?
Understanding yesterday that he's requesting that I be released. I don't know if I'm fine to stay on if that's what you decide, but he has expressed to me that.
He's
he
a
does
fine
not-
lawyer, he wins cases, but you can hire anybody you want, but you're not able to hire somebody, are you? Well, you get a competent lawyer and she's competent. That's who you get. Do you want to continue to represent him?
It's his decision, Judge.
No, it's not. No, he can go hire anybody he wants, but the taxpayers' money is controlled by me and he gets a competent attorney, which you are. But there are other competent attorneys too, but what do you want? You've talked to him. You think it'd be in the best interest of justice to replace him with somebody else?
I think so because
Then
we
it's,
do not have conversations with each
Then
other.
that's done. You don't know who you're gonna get, but it'll be somebody who's competent and they'll represent you. There aren't any deals. Let's get this to trial as soon as possible. The next person on the list, get him represent and let's move forward. Thank you. I've got John Dixon.
Yes, Judge. He also wants his case set for trial.
Getting him out. What's the offer on this?
Half of 10.
Look at and see. Gonna end up being a cap of 20 here in a minute. All right, come on up. 24 CR 2417. You were John Dixon? That's it. And you were charged with a second-degree felony of aggravated assault with a deadly weapon. If convicted, it carries with it up to 20 years in prison and also parole if convicted and sentenced to imprisonment. You will not be paroled until you have served 1/2 of your sentence. Do you understand? Due to the deadly weapon allegation here. What are we gonna do? Yeah, Ms. McNally is your attorney.
He was just set his face for trial.
Okay, is he eligible for probation?
He is, Judge.
Oh, yes, is he?
He's eligible for potentially deferred from you if we would have proceeded with the cap of 10. But he's also eligible for straight probation from jury.
Hmm.
He doesn't have any prior criminal history.
Okay. The victim in this case, y'all talked to him, I guess, and he's wants to move forward. Sometimes that doesn't happen, and that's why I don't want, this time is so valuable. I don't want, sometimes people do things and they don't help. But y'all are ready, willing and able with the, okay. Then it'll be set for trial, and this one looks, we can try it very quickly. Let's move this fast. Okay, you're gonna represent him?
Yes, Judge.
Okay, good deal. Thank you. That's all. We'll set it for trial. Devontae Huff?
Judge, can we reset him to a NTRP hearing docket, please? That was Ms. Staub's case. I have not had an opportunity to reach out.
Bring him out. We're gonna do the MTRP hearing. Give him what he needs to know about, so we don't wait. You know, we can make a decision here, but I don't want to start over in 2 or 3 weeks. I'd rather pick up where we are so he knows. This delay stuff is just killing us. On back in the house and the jail. He's got 2 cases,
He
right?
is, Judge.
Are they both MTLP?
They are.
Oh, yeah, okay. You're Mr. Huff?
Yes, ma'am.
Got you on 2 cases here, sir. 24 CR 155, 24 CR 169. Who's on this?
It was Ms. Staub. I don't think another prosecutor has been.
Looks like me, Jeff.
Okay. Look at you.
I'll be missed off since she's on.
Each of these cases are motions to revoke unadjudicated probation. You're charged with state jail felonies of criminal mischief. It looks like you were placed on probation for up to 5 years. On December 2nd, and he's already pleaded true.
Yes, we were here once before, Judge, and he was reinstated because there was a significant amount of restitution involved in the cases. And now we're back here again.
They locked me up for trespassing one. That's why I'm in jail. I went here for a motion to revoke. They locked me up for
Do
trespassing.
y'all need to amend this motion?
I don't know, Judge. I have not looked at it.
It does need to be amended, Judge. There has not been a first.
Okay,
amended
so
filed.
there's a substantive offense that's come along, allegedly.
There's subsequent allegations. I'm not sure if it's a substantive offense, but
But we put him on probation.
in December of 2024,
I'm talking about this allegation true in June. What did I find then? What was my resolvement on this?
you reinstated his probation.
Okay, that's done. What happened subsequent to that?
I don't know. I don't have a new motion to revoke probation filed.
He failed to report, Your Honor. He hasn't reported since continued on probation.
Okay.
It's my understanding.
yeah, I have
he
my-
absconded.
You're interrupting.
Yes, sir.
Yeah.
But I'm a lawyer too.
Is that just a smart aleck comment,
No, that's
or
not.
just
No, sir.
you're gonna step over me
No, sir.
all the time, the whole time?
No, sir.
Shh.
Yes,
You're
sir.
gonna get a chance to speak, but the lady has to put down everything as the court reporter, and when 2 people are speaking, she can't do it. That means somebody gets in trouble. All right. Okay, so the
I'm sorry, by Joe.
motion, sounds like another motion to revoke probation needs to be filed.
And it seems like I have some motions that I need to file as well, Judge.
All right, then,
Seems like.
can y'all do that in 2 weeks,
sir.
everybody? So this man knows what direction he's gonna be heading in?
Yes, sir.
All right.
Please.
All right, that's what we're gonna do. See you back in 2 weeks, sir.
Yeah, thank you.
Okay, here.
Well, I don't know about all of you, but I sincerely hope they're able to reach resolvement on that one. Let's go to Judge Boyd.
Yo, Martinez, can I have parties announced for the record?
Lauren Espinoza for the state.
Morning, Your Honor. Daniel De La Garza for the defendant.
Good morning. And are you Mr. Martinez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the document titled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial?
Yes, ma'am.
Did you understand that your attorney has certain rights? He has the right to have 2 days pass once he's presented with the information and also 10 days to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? You're going to need to speak up. The court.
Yes, ma'am.
Court needs to hear. Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Mr. Martinez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with attempted to commit manufacturing or delivery of Group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, you will be deported, denied re-entry, and denied naturalization?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Are there any applications?
No, Your Honor.
Any objection to the court marking the box that says there are no applications?
No, Your Honor.
All right, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine, no applications. This will run concurrently with 2022 CR 7495. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, state over state exhibit 1 and all attachments, and then for their record, state wanted to make it clear that the labs have not been received yet in this case, but at the request of defense, we're proceeding with this, despite that.
And that's why we're doing the attempted.
Then. All right, we can go off the record. So if y'all are gonna do attempted and there are no labs, then there has to be a guilty plea, because otherwise, if the officers just did a presumptive test at a stop or something, that's not admissible into evidence.
He can change his plea, Your Honor, but you want to do that?
Yeah.
He'll change his plea.
All right, so how do you plead?
Guilty.
All right, and then you're offering into evidence?
Yes, state exhibit 1 and all attachments.
Any objections?
No, Your Honor.
All right. And Mr. Martinez,
Yes, ma'am.
do you understand you have a right to have the labs for this offense be given to your attorney so they can make it, so you can make an informed decision on whether or not this actually tested positive for methamphetamine or not?
Yes, ma'am.
And do you understand that any presumptive tests that were done by the officers in the field are not admissible?
Yes, ma'am.
Of course, if there are objections,
Yes, ma'am.
but it's not admissible into evidence. Do you understand that?
Yes, ma'am.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am. Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, just that he takes responsibility for what he's done and wants to go sit down for a little bit, come back to our community and hopefully do a good job.
All right. Then the court will sentence you to 5 years in the prison. Court will give you credit for any time served. There's a $1,000 fine, time and money to run concurrent. This will run concurrent with 2022 CR 7495. There's to be no contact with Amanda DeLeon. There's to be no unsupervised contact with minors and no residing in household with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're proceeding in 2022 CR 7495. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Sergio Martinez Jr. who was placed on deferred adjudication in 2022 CR 7495 for the offense of burglary of a habitation on November 16, 2022 for a period of 8 years? Is that you?
Yes, ma'am.
State?
Violating condition number 4 in Bexar County, Texas, the defendant Sergio Martinez Jr. did then and there fail to report to the supervision officer as directed for the months of May, June, and July 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State will waive the rest.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion, revoke community supervision, deferred adjudication, enter an adjudication of guilt, sentence to 5 years TDC, and run concurrent with 2025 CR 012772.
All right, has he done anything on probation? Have you done anything?
No.
All right. Then you have not done anything on probation. You're looking at 20 years. You're placed on probation for 8 years. So why should I give you 5 years?
Think I deserve another chance, ma'am.
No, I mean, here's the thing. You're on probation for burglary of habitation. It's involving the complainant, and there is a no contact order with the complainant. And then you have the case that you've just pled to. And the reason why the police were there is because there was an altercation and there was a female involved and there was a chunk of her hair missing. And you said it was a misunderstanding. So it appears that you have not learned anything. Thank you. So this is what the court is going to do. The court is finding violation of condition number 4 true. There's to be no contact with Teresa Sheets. This run concurrent with 2025 CR 012772. Court will give you credit for any time served. There's to be no residing in any household with minors. There's to be no unsupervised contact with minors. The court will sentence you to 8 years in the prison. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement. I'm sorry, this is not a plea bargain agreement. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Right. Yes.
Any approach?
Yes.
This is regarding the other pending case that the defendant had. Rick Pena for the record.
And the court is being tendered a dismissal in 2025 PF 37778.
Thank you, Your Honor. I'll take this down. And it's in this corner.
All right, thank you. Good luck to you.
Thank you, Your Honor.
You're welcome.
Alrighty, let's continue our Texas ping pong and go back to Stevens.
Quick, present with Ms. McNally, his attorney and the state's attorney. Does the defendant waive a formal reading of this indictment charging him with the 3rd-degree felony of deadly conduct? And can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about May 5th, 2025, in Jefferson County, Texas, you committed the 3rd-degree felony of deadly conduct by discharging a firearm in the direction of a habitation. Do you understand what you were charged with here, sir?
Yes, sir.
This is a 3rd-degree felony if convicted, which means you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that's applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. You do well, and it gets closed out early in a third of the time. Another case, 25 CR 1289 will be dismissed. What is that?
It's a misdemeanor. On the
Oh, okay.
weapon, Judge.
And then you've got this Glock 19 that was involved here. This is going to be forfeited as part of this agreement to the state. Is that your understanding of the agreement?
Yes,
And it
sir.
was a $500 fine also on this deferred or unadjudicated probation. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead in this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes.
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You voted it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. John West is on the YouTube, and His tie is showing. Um, This is, do you understand all of this to be true and correct, sir? In State's Exhibit 1. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived? Yes, Judge. All right. If nothing further, I'm going to follow this agreement. McCarrick, anything you want to add? All right, if nothing further, I'm going to find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation. This will be up to 10 years in length. You will be fined $500. You do well, it will be shortened. There's a Glock 19 that is described in this plea agreement that will be forfeited. I guess that was recovered from you during an arrest or search of some kind. Also, there's another case pending 25 CR 1289. That case will be dismissed as part of this agreement. Anything else we missed on? You're going to see the probation officer here in just a moment. He will go over all these terms and conditions of probation. Do well. It's in your best interest. You become a better person. And this gets shortened. You don't get a conviction. If you fail, your case could be revoked. You could be found guilty then and sentenced up to 10 years in prison. And then that comes with all kinds of problems. This alleges that you discharged a firearm at or in the direction of a habitation. The use of a firearm in the commission of an offense, if convicted, will affect your parole poorly. It has a negative effect on it. You understand? So move on with your life and do better. Okay. All right. Please see that nice man. We'll see him. Thank you. Do well. Yes, sir.
And back to Judge Boyd.
How's it going?
It's going well.
How's your father doing?
Yeah, been better.
Yeah.
Tough weekend.
Oh my gosh. I looked up at the score and I
Yep.
was like, "Oh." Well, let me just tell you, Oklahoma didn't win and LSU was playing as though they didn't want to win. So what can you say? So on this case, an offer was due today. Has that been tendered?
Yes, Your Honor.
And Your Honor, I know that Robert was just appointed to this case this morning. So we have actually not had a time to review any evidence or any discovery in this case.
All right. So then, Ms. Ferguson, I'm going to give you a 30-day reset. If your attorney wants you brought back sooner, then they can have you brought back sooner and placed on the docket. And this will be your plea deadline date. You said 13th?
Yeah.
All right, so we'll see you back in November.
Thank you, Judge.
Thank you.
Thank you.
All right, who next? Deontay Harrell? Court is calling 2017 CR 7886 State versus Deontay Harrell. Can I have parties announced?
Rick Pena for the state of Texas. Arenado Vasa for the defendant.
And are you Mr. Harrell?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Deontay Marquise Harrell who was placed on community supervision in 2017 CR 7886 for the offense of assault, family choking, strangulation on May 29th? On May 2nd, 2019 for a term of 10 years. Is that you?
Yes, ma'am.
State?
Yes, Your Honor, violation of condition number 2. On or about the 11th day of January 2023 in Bexar County, Texas, the defendant, Deontay Marquise Harrell, did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True. Violation condition number 2. On or about the 22nd day of March 2023 in Bear County, Texas, the defendant, Deontay Marquise Harrell, did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True. Violation condition number 2. On or about the 8th day of June 2023 in Bear County, Texas, the defendant, Deontay Marquise Harrell, did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
True. The state will waive the other violations, Your Honor.
Any objection?
No objection, Judge.
All right. Did you understand by pleading to that, those violations, the court could find it true, grant the motion, sentence you up to 10 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations of 2, 2, and 2?
Yes, ma'am.
Court will find 2, 2, and 2 true. Is there a proposed agreement?
There is, Your Honor. That is to deny the motion, alter and amend conditions to add safe P followed by safe P aftercare.
All right, the court is not going to follow that agreement. This is his 5th motion to revoke. And each time the issues have been, they've tried to address those issues. Before I was judge, there was a motion to revoke in 2018, a violation of condition number 2. So that judge gave you intensive outpatient treatment. Then in 2018, there was another violation that you pled true to a violation of condition number 1. That judge gave you 0 tolerance. And then on May 1st, 2019 with me, there was a violation of 18, 22, and 23. And on that date, the court found you guilty because you were previously on deferred. So the court ordered conditions that would help you be rehabilitated. Then you came back on March 28, 2022. There's a violation of 2, 5, and 15G. And the court did a referral to Center for Healthcare Services. And now we're back here with the same violations. There's nothing else left that the court can do. So the court is finding 2, 2, and 2 true, and the court is going to revoke. What is the request for time?
We'll defer. I may have 1 second, Sean.
Yes. All right, state, what are you requesting for time? Or if you're not requesting any, I'll make a ruling.
They will ask for 10 years, Your Honor.
All right, defense, what are you requesting?
Your Honor, we're asking for 3.
All right. So the court is going to revoke. The court is going to sentence you to 6 years in the prison. The court will give you credit for any time served. Just one moment. Not this one, the other. Yes, thank you. All right, so the court is going to revoke, sentence you to 6 years in the prison. Finding of family violence in the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question about that, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and also there's to be no residing in any household with minors. All right, good luck to you.
That will be excused.
Yes.
And that brings us to the end of today, friends. I hope you all had fun. I know I did. The weekends are lonely without you guys, but we come back on Monday and it's always good to see everybody. So thank you so much for joining me. Be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. So if you're a channel member, be sure to join us for the pre-show. Also, always remember that we're putting out videos pretty much all day long. Three regular videos every day. Bringing back shorts, posting those again. And then we have Sidebar Tuesdays and Thursdays as well. So lots going on. So your one-stop shop for your courtroom needs here at TCF. But yeah. Go have yourselves a great day today. Make it the best. We'll see you tomorrow. Take care. God bless.